Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1179. Alon Farhy versus Commissioner of Internal Revenue appellant. Ms. Ugolini for the appellant, Mr. Robbins for the appellee.
Good morning, Ms. Ugolini.
Good morning. May it please the court, I'm Francesca Ugolini, counsel for the Commissioner of Internal Revenue. The question in this case is how the government is supposed to enforce the Section 6038B penalty against people like Alon Farhy, who simply refuse to pay what they owe. He admits he willfully failed to report information about foreign corporations that he used to hide over $3 million from the IRS. He admits that he has no reasonable cause for this failure, that he owes the amount, but he says the IRS cannot collect it from him. The tax court went astray in accepting this argument because the IRS has the power to assess this penalty under its broad grant of authority in Section 6201A of the Code. This is supported by the statute's text, history, and context. The text of the statute speaks in very broad terms. It says the secretary is authorized and required to make the inquiries, determinations, and assessments of all taxes, including interest, additional amounts, additions to the tax, and assessable penalties imposed by this title, that's all of Title 26, or accruing under any former Internal Revenue law. We submit that the term all taxes should be read to include the Section 6038B penalty because the parenthetical that starts with including broadens the term taxes to include other tax-related items, such as interest and various types of penalties. As this court and the Supreme Court have held, the term including is illustrative, not exhaustive.
Ms. Ugolini, I think it's difficult because we know from Sebelius that taxes and penalties are distinct generally, unless we have a textual reason to think otherwise, or perhaps structural reason to think otherwise. And the parenthetical including references at least three specific categories of penalties: the additional amounts, additions to the tax, and assessable penalties, and arguably creates a negative implication that those specified ones are the kinds of penalties meant. It doesn't say other penalties. So what is it that you're relying on? You're relying on the fact that other types of penalties are referenced and that the parenthetical itself modifies the definition of tax, and that therefore we should see the parenthetical as implicitly including other like items such as the 6038B penalty.
And I would push back, I think that's right, you've correctly summarized our argument, but I would push back against the notion that the fact that three types of penalties are listed creates a negative implication that other types of penalties that are similar in character to the enumerated types of penalties are not included. The case law does not bear out that sort of negative implication. On the contrary, the case law makes very clear that there's a presumption that including is illustrative and not exhaustive. And when looking at what else might be included in a non-exhaustive list, it's appropriate to include other items that keep company with the enumerated items.
What about, oftentimes Congress will say including but not limited to, and then obviously we know that it's not an exhaustive list, but they didn't use but not limited to here.
That's correct. I mean, that would make it even more clear that including is illustrative and not exhaustive. But this court, we cited a few cases in our brief, the FDA case and I think it's the American Hospital Association case, interpreted the word including as illustrative and not exhaustive, notwithstanding that extra language that would have really made it clear was not part of the language under consideration.
You also rely on 7701C, which says that where including is used in a definition, it's intended to be, not exhaustive. But I don't see that that helps you with 6201A because 6201A is not a definition.
That's fair. I think 7701 does not get us all the way there. But as I said, this court's case law and the Supreme Court's case law bear out the interpretive principle that the word including in a statute, particularly in a list like this where there's a parenthetical, introduces a non-exhaustive list of items. And even the tax court recognized this. That's on page 250 of the joint appendix in its opinion. It recognized that this phrase in 6201 is not necessarily limited to the enumerated items, but the reason it gave for not reading the language as covering the section 6038B penalty is because it said, well, this penalty bears no resemblance to taxes, whereas the other items in this parenthetical have some relationship to taxes. But that's not true. The other types of penalties that are specifically listed, additional amounts, assessable penalties, if you look in chapter 68 of the code where those penalties are all listed, there are plenty of fixed dollar information reporting penalties similar to the 6038B penalty. This is very similar to penalties that are explicitly included in the parenthetical. And this does bear a close relationship to taxes because the form that was required to be filed here is filed with an individual's federal tax return. It provides information about foreign income and assets and transactions that allows the IRS to determine a person's tax liability. And if you look at section 6501, which provides limitations periods on assessment of taxes, there is a specific provision that references 6038 saying, if it turns out you did not report anything related to a foreign corporation, the limitations period doesn't start until this particular form required by 6038 is filed.
Can I interrupt you? Can you tell me whether there's any aspect of the penalties that are set forth in 6038 that cannot be enforced if the only enforcement mechanism is a civil suit?
No, I mean, so 6038 has two penalties. One is the reduction of the foreign tax credit, which I don't understand there to be any dispute that the IRS can assess that one because the reduction of the foreign tax credit results in an increase in tax. So the IRS has the power to.
I mean, I just interrupt for a second. It doesn't, we'll find out from your friend on the other side, but they don't seem to concede that, at least explicitly in their briefing. Did I miss that?
I suppose, I don't know that they, I may have misspoke. I don't know that they conceded. I mean, the tax court, I think, seemed to recognize that the foreign tax credit reduction penalty in 6038C was assessable. I mean, that penalty results in an increase in taxes. And so under the plain language of 6201A, the IRS would have authority to assess an increase in taxes that is occasioned by reducing a credit.
But the 6038C foreign tax credit reduction, that goes through the process for deficiencies. That's something that is subject to collection due process hearing and appeal to the tax court, unlike 6038B penalty for failure to file. Is that right?
I believe that's right. I believe that the reduction of the foreign tax credit would result in a tax deficiency that would then require that to go through deficiency procedures.
Right, and that would send it to the tax court, whereas the 6038B goes through basically its assessment and levy.
Well, so if the penalty is assessable by the IRS as the government contends, the IRS would send a notice of the penalty assessment, and a taxpayer would not have the ability to challenge that in a deficiency proceeding in the tax court. But the taxpayer would be able to bring the very type of proceeding we have here, which is a collection due process proceeding. What Mr. Farhy did was he didn't pay the penalty. He waited to get a notice of intent to levy. That presented him with administrative appeal options before the IRS. So that's a prepayment remedy, and then allowed him to appeal to the tax court. Now, however, if the 6038B penalty is not assessable by the IRS, then taxpayers do not have that option. The IRS would just—
Wait, he can or he can't go to the tax court on the I thought he couldn't go on the 6038B.
He
Because under, I'm thinking about Wheaton and Smith and and actually Our Country Home.
He would not be able to go to the tax court in a deficiency proceeding, meaning he wouldn't get a notice of deficiency saying you owe this and you get to challenge this. But he would be able to go to the tax court for a collection due process proceeding. And that's
To the IRS for the collection due process. That's not going to the tax court.
well, it goes first to the IRS. You get your administrative hearing before the IRS. And then if you disagree with the notice of determination that's issued, you can appeal that to the tax court. And that is how this case came up.
But I thought the collection due process hearing was within the IRS.
It is within the IRS. That's right.
It's not within the tax court.
The initial administrative hearing is within the IRS, but then the same statute that allows that administrative hearing, which is section 6330, if you look at section 6330D, it allows the taxpayer to appeal the IRS's determination to the tax court. So if you're unhappy with the outcome of the IRS administrative hearing, you can appeal to the tax court, and that's what Mr. Farhy did in this case. And then the tax court basically, vacated the penalties because it held that the IRS lacked assessment authority, and that's now this appeal.
So is it your position that the term assessable penalty applies to a penalty that is subject to a deficiency proceeding, and it also applies to a penalty that is not subject to a deficiency proceeding?
Our view, so assessable penalty is defined nowhere in the Internal Revenue Code. The government's view is that an assessable penalty refers to any type of penalty that Congress has not specified must be collected by a civil action. So in this case, we haven't directly argued that this is an assessable penalty, but we think that would be a fair interpretation. But to answer your question, so I think in the tax court, the commissioner initially had made an argument that an assessable penalty means any sort of penalty that skips over deficiency procedures. We're not making that argument anymore. But ultimately, if this penalty is assessable, a taxpayer can get tax court review. It just would come up through a different procedure than the deficiency procedures. It would come up like this very case did, where you get to have an administrative hearing before the IRS. Not only do they look at the legality of the penalty, but they look at collection options. If the taxpayer can't afford to pay it, that hearing is the opportunity to make an offer to establish an offer in compromise, enter an installment agreement, work out payment options with the IRS. All of that is then reviewable in the tax court. And so you're still in a prepayment posture, but you're just in a different type of proceeding than a deficiency proceeding. And then it's reviewable by this court.
Can you?
Go ahead.
You agree that there are some penalties that are not assessable penalties, right?
That's correct. There are two penalties in the code that where Congress has specifically said they must be collected by civil action. There was actually a third when this assessable penalties language was added to the code in 1954. At that time, Congress also added 3 specific penalties that had to be collected by civil action. One of those has since been repealed, but it's our position that that language, assessable penalties, is meant to distinguish from the penalties that specifically have to be collected through a civil action.
And those two, just to remind us, are?
They are 5761 and 7269. And then the 54 code, as I mentioned, also added 7263, which has since been repealed. But so what we have in this case, though, is congressional silence. The commissioner has recognized, we've recognized in our brief that there's not an explicit coverage for the 6038B penalty. But given the broad, in our view, non-exhaustive language of the parenthetical in 6201A, and the fact that Congress has accepted other penalties from the IRS's assessment power, we think the right way to read the statute is that this penalty is covered by the IRS's assessment power.
In my view, one of the most persuasive parts of your argument appears at pages, I think, 13 to 15 of your reply brief, where you basically talk about how there are some penalties where Congress uses language that clearly indicates that they are to be assessable penalties that wouldn't be able to be assessed under Mr. Farhy's reading. I think section 45, and I don't know if you cited it in your brief, but I think section 6038C might also be an example of that. I guess what I'm trying to determine is I'm going to ask this question of Mr. Farhy's counsel. You know, what are we to, I guess, make of that, given that his argument is that, well, the commissioner's reading renders some language surplusage as well?
I think, and we would submit that frankly, under either reading, there's surplusage in the statute. I mean, just the very fact that there's 6201A, and then there's two other provisions, 6671 and 6665, all repeat the same assessment authority for the same category of penalties. So I see I'm over my time, so I don't want to keep talking about that unless you would like me to.
You can keep going. We have a custom in this court that we will, as long as we have questions to ask.
Okay.
That we're not holding it against your rebuttal time.
Okay, thanks very much. I was just going to say that I think the tax court was very persuaded by the notion of surplusage, and that was what led the tax court to rule against the government in this case. But I think surplusage is not a useful canon in this case because there is surplusage under either interpretation. And I think the duplication and the surplusage in this case really is a red herring because at the end of the day, Congress only needs to provide assessment authority once. And we submit that it did so in 6201A, that language is broad, that the parenthetical is non-exhaustive, and that it can cover other similar types of items that are not expressly listed.
So let me just, I know we went through this once, but so tax, and then it needs the parenthetical in 6201 in order to make clear that in this context, tax includes penalties, because ordinarily the default rule under the code is that a tax is different from a penalty. And your argument is, therefore, that the parenthetical is not defining, well, I guess it is defining tax, but it's extending the definition of tax.
Correct.
But that the parenthetical itself is non-exhaustive so that it extends it in a way that is susceptible of including a penalty that is not denominated an assessable penalty, but should therefore be treated as an assessable penalty. Is that right?
That's right. And if I could just add, an additional thought to why that list should not be read as a discrete list. The three types of penalties mentioned on that list, these are not neatly identifiable categories.
Well, they do correspond to subchapters in the code.
They do. However, even the tax court recognized that items outside of Chapter 68 are assessable by the IRS. And the code has yet a further provision in 7806B that says no inference is supposed to be drawn from groupings and labels within the code. And as we pointed out in our reply brief, two circuit courts, in the context of construing this very same language as it appears in a different statute in an interest provision, refused to read this same list as limited to items in Chapter 68. It construed the list according to its plain terms, and that's the motor fuels carrier case that was by the appellate division of the Court of Claims, the predecessor to the Federal Circuit, and then the Ninth Circuit in the Bardall case. The facts of those cases are a little bit complicated, and I'd be happy to explain them, but my point is that two circuit courts have already construed that exact language according to its plain terms and not limited specifically to Chapter 68.
But as I recall, we have a much more recent case that goes the other way. I'm just searching for that.
Fourth Circuit. To the Fourth Circuit.
The Fourth Circuit case. Which is, sorry, I'm just looking for it. You know, I'm referring to Ms. Ugolini.
I'm afraid I don't. Was this a Fourth Circuit case that related to one of the Affordable Care Act penalties by any chance?
Well, let me just ask so I'm clear
Sure.
where Judge Pillard was asking you, just sort of summarily here. Basically, your position is that Congress gave the commissioner very broad authority. And absent indication, clear indication by Congress that it's taking it away or it's limiting it somehow, the IRS should be viewed as having the authority just based on what I'll call the plain broad text and this non-exhaustive parenthetical, and that all of the canons that usually apply simply don't apply where the tax code is involved.
I would agree with everything except the very last statement. I don't think we're saying that all of the usual canons shouldn't apply, but I think.
Well, I'm thinking about, you say, you know, there's surplusage, depending on your point of view, no matter which interpretation you think is the right one. So that canon is out of the, sort of not involved, and canons about, you know, specificity versus generality. That's what I'm thinking about, those canons that we often use and that the Congress, at least the committees, use in trying to understand what was the congressional intent. And there have been some articles written by the Academy saying that, you know, we're both, that is, courts and the legislature, are proceeding on paths that really don't coincide with one another's understanding of what's happening in the legislative process. So that here, that your argument falls very much in line with that thinking. We have some broad text, the usual canons that we look to don't apply. And when you started out and you characterized your colleague's argument, I thought it wasn't that there was no way for the commissioner to collect, but rather he had to do it in a certain manner, namely through a civil action, not by assessment.
Right, so that would be a civil action brought by the Department of Justice. It would not be a proceeding brought by the IRS. But I guess I just wanted to respond to your point about, I mean, the larger question of congressional intent. You know, this statute, this penalty was added to the Internal Revenue Code in, I believe it was 1982. So it has been out there for more than 40 years. In 1997, so the IRS has been assessing and collecting this penalty per its broad grant of authority under 6201A since that time. In 1997, so at this point, this is 17 years into this well-established administrative practice, Congress increased the penalty from, at that point, I think it was $1,000 initial penalty to a $24,000 continuation penalty. It increased the penalty to its current amounts of $10,000 and $50,000. And in all of this time, including with, you know, as the appellee has, as you know, Farhy has pointed out, complaints from the Taxpayer Advocate Service about, you know, the IRS enforcing this penalty. In all of that time, Congress has never seen fit to step in and change the way the IRS is assessing and collecting this penalty.
So one of the concerns that I understand is raised by the IRS's position here is whether, given the, what is it called, the pre-appeal conference that one can get, and this is an issue, or sort of the overall process, I think is well described in Our Country Home Enterprises, the Seventh Circuit case. If a taxpayer has a pre-appeal conference, like as in that case, then they don't even get the collection due process hearing, and therefore that truncates, that prevents them from going even to the tax court. So that was a case in which there was a tax penalty, and then there was a failure to file penalty. And I guess my question is whether the alarms that are raised, that let's say Mr. Farhy had had a pre-assessment conversation with the IRS under Our Country Home, the concern is that that could cut off his ability ever to have tax court review of this filing penalty?
So I'm not familiar with the Our Country Home case, and I'd be happy to, read it and submit a supplemental letter. But there is no, first of all, in the context of the 6038B penalty, there is an opportunity to confer with the IRS before assessment, is my understanding, because what happens, and this is explicit in the statute, the IRS is supposed to send a notice of your failure to file, and the notice says you failed to file, but if you think you have reasonable cause, write us and let us know, what your reasonable cause is. And that's also explicit in the statute. I think it's 6038C4 specifically requires the secretary, so this is the IRS, to make determinations about reasonable cause. So there is some opportunity for a sort of conversation with the IRS about whether you owe this penalty in the context of learning that, you failed to file. But as to the point of, is it possible for tax court review to be cut off? I'd have to take a look at the Our Country Home case. I really don't see how that is possible.
That is, there is some concern in the scholarship and that this would happen to someone who's facing a reporting penalty. And if they do have a pre-assessment process, even with the IRS, that they would not have an opportunity for collection due process hearing, because that would be a second similar hearing,
Okay.
and therefore they would not have an opportunity to appeal to the tax court. And the question I was going to ask,
Okay.
although it's a little bit unfair, but I'm just put it out there anyway, is in Our Country Home, there were kind of two tracks going on. The tax court was there was a deficiency proceeding on the tax liability, and a tax penalty was folded into that. But the penalty for failure to report was going on a separate track because it's not subject to a deficiency proceeding. And one way of understanding the situation there, where the taxpayer was unable, due to the pre-assessment interaction with the IRS, to have a collection due process hearing and go to the tax court, one way of understanding that, and this is what I'm wondering whether I'm correct about this, is that the liability was being determined, the same liability that would affect the filing penalty, the failure to file penalty, was being determined in a proceeding that was going to the tax court on the deficiency, and that therefore the tax court's determination of that liability would collaterally stop any treatment of the filing penalty. The only thing that wasn't collaterally stopped on that was the amount of the filing penalty, and perhaps something like payment terms. But that is one of the concerns that your position raises, and it would be helpful if you are able to address it.
Yeah, and so actually I think now, and like I said, I'd be happy to take a look at Our Country Home and send in a supplemental letter, but I think that I know now what you're getting at in that case. In the collection due process statute, that's section 63330, it does say that if you have had a prior opportunity for meaningful review of, let me just back up. Usually a collection due process proceeding is an opportunity for the IRS to check that, the procedures of law were followed here. It's an opportunity to review collection alternatives if the taxpayer can't pay, and balance the need, of like taxpayer enforcement with sort of fairness to the taxpayer. Now, the statute does say, so normally it's not a place to review your underlying liability, but the statute does say that if you did not have a prior opportunity to contest your liability, then you can contest your liability in a collection due process hearing, and then that's also reviewable by the tax court. And so, yes, there are a lot of cases out there where that question, has been litigated, where maybe a taxpayer did have a prior opportunity to have their tax liability reviewed. That might have been in a tax court deficiency proceeding, and then the question becomes, okay, so you had your first bite at the apple. Then you didn't pay. Now we're talking about collection. And so in the collection due process hearing, the taxpayer wants to raise challenges to their liability again. If you had your first bite at the apple, you don't get the second bite under the CDP statute. So I think that's what Our Country Home is probably talking about. But that would not happen in the context of this penalty, because this penalty, the 6030B penalty, is not subject to deficiency procedures in the first place.
Well, it's the same penalty in Our Country Home, except that because there's also a penalty for failure to pay, that same issue is going through deficiency procedures, even while the 6038B isn't. So there's kind of a coordination issue. I actually have a related question, and it makes sense to me that you wouldn't have a second chance, partly because if that same liability issue is going to the tax court, why would you have a separate tax judge looking at the same issue? You would have incompatibility questions. There's, collateral estoppel as between whichever one goes first, and there's just a coordination issue. And I guess the same is potentially true of Mr. Farhy's position. If you're thinking about the coordination between 6038B, the fine amount, the dollar amount, and 6038C, which is the offset, and the coordination between those two. Under Mr. Farhy's position, if the IRS has to have the Justice Department go to court in order to collect the 6038B, then where is the opportunity? You haven't made this argument, but I'm wondering why. Where is the opportunity to coordinate? You're going to have the federal district court in the 6038B proceeding determine liability, and a tax court in a case in which there's also a tax deficiency and potentially penalties related to that, or the offset that is going to be wrapped up into the deficiency proceeding, right?
Right. Although I don't know, and I would have to take a closer look at whether the foreign tax credit reduction penalty and the fixed dollar penalty, I know they have to be coordinated. The statute provides that you can't have both, but I'm not sure if they're actually sort of intermeshed. I'm not sure if the way the IRS does it is they decide whether to assess one versus the other. So that if you have—
They offset the dollar amount against the reduction in tax. So at the end of the day, the whole case has to come together. But even more fundamentally, if there's a proceeding on the tax liability and the offset, putting aside the offset,
Right,
and the percentage penalty, then you could have a federal district court determining the same liability question, no? And it seems like you have an even more serious collateral estoppel problem than in Our Country Home. And whereas in Our Country Home, the IRS is in a position, as they did there, they stayed the proceeding, the final levy on the filing penalty, pending the outcome of the related deficiency procedure and appeal to the tax court. And that sort of allows the IRS to be in the driver's seat and make sure that if they lose, for example, on the liability issue in the tax court, that they'll just drop the filing penalty.
yeah, I'm not sure how often. I know one of the reasons the 6830B penalty was enacted, this is in the legislative history, is that the 6038C, the credit reduction penalty, was confusing and hard to figure out. It only applies if the taxpayer paid foreign taxes to begin with, and so you get a foreign tax credit. So I'm not sure in practice how often this problem arises where you've got sort of a mix of both penalties, and then you've got maybe like a deficiency piece to be worked out, and then a non-deficiency penalty. But I would just submit that this entire procedural morass that you're describing is more of a reason to keep this in the IRS's hands.
Exactly. And that's
versus sending all of this to the Department of Justice to sort out.
That's my question. I wonder whether I'm correct about that and why it's not an argument that you relied on. And so, yes, it's effectively a friendly question, but puzzlement about whether I'm right about that as a structural matter.
I think I need to think about it a little more. And like I said, I'd be happy to send a letter following up about Our Country Home. I think you are right that we did posit in our brief that sending these cases to the Department of Justice would be worse for taxpayers for a few reasons. Mainly because they would not have the opportunity to go to IRS appeals or have a collection due process hearing. One other reason is actually if the penalty is subject to assessment by the IRS, there's yet a further statute, 6751, that requires supervisory approval for those penalties. But if all of this is in DOJ's hands, all of those taxpayer protections go away.
But it's also way worse for the IRS because, how often are you going to be able to get the Justice Department bringing lawsuits? There's a reason that Mr. Farhy's on the side he's on, notwithstanding what you say about it being better for taxpayers to.
Right, no, and it's certainly better for the
IRS.
government. I mean, no, and there's no question. I mean, the IRS they are the tax collection experts. They have the capability and the machinery and the know-how to do this. One other, piece that is less favorable to the government under the tax court's ruling is that the government DOJ would have half as much time to collect than the IRS does. In the code, Congress gave the IRS 10 years to collect an assessment, but under just the general 28 USC statute, I think it would be 2462, the Department of Justice would have to bring a civil action within 5 years. So certainly, it's certainly better for the government that the IRS be able to assess this penalty. But I wanted to point out that it's also better for taxpayers as well. I've used up a whole lot of time. Sorry.
Well, there are a number of provisions in the code that provide for penalties in the context of criminal offenses. And one thing that occurred to me, not as a tax expert, is assessable penalties in the list, in the parenthetical, might be distinguishing from penalties that must be collected by criminal action. But is it the case that the IRS can also assess penalties that are subject to criminal proceedings, or no?
So my understanding in a criminal context is that, if there's a penalty that's actually a criminal fine, that has to be determined in a criminal prosecution. But in terms of other civil penalties that might be available, I mean, that civil proceeding always would come after a criminal proceeding if there is one. And so anything related to assessment would come afterwards. The IRS doesn't proceed with the civil side until after the criminal side is over.
And just to be clear, you're not arguing that the 6038B penalty is within any of the terms explicitly listed in the parenthetical?
I mean, we haven't made that argument explicitly in our brief. I mean, we do think that if you looked at the plain meaning of those terms, the code nowhere defines what an additional amount is. The items listed in Chapter 68A that are put together as additional amounts and additions to tax include things like failure to file penalties.
That you're bringing me back to the thing I left hanging. It's the whistleblower case, the tax court case that I was thinking of that does treat the additions to the tax and additional amounts as terms of art. And you were saying that those are broader, more encompassing, undefined, but the tax court actually has said otherwise.
That's right. The tax court in that whistleblower case was looking at, so that's a different statute, 7623, and it lists the items that, if a whistleblower provides information and the IRS ends up collecting proceeds as a result of that information, then the whistleblower gets a percentage of the collected proceeds. And so I believe the statute lays out, it lays out what the pot of available funds are. And I believe in that case, the dispute was over whether an FBAR penalty that was collected, so those are penalties collected under the Bank Secrecy Act. This is administered by the IRS under an MOU with FinCEN, but the IRS is also involved in collecting, assessing and enforcing FBAR penalties for failure to file
FBAR,
FBAR. It stands for, it's like a foreign account reporting penalty under, I think it's 31 USC 5321. And so the question in that case was whether, I guess the IRS ended up collecting additional taxes from the underlying taxpayer, but then also realized there were these unfiled foreign bank account reporting forms and collected FBAR penalties. And the question was whether, I think the FBAR penalties counted as additional amounts that were part of the pot. In that case, I mean, I don't think the tax court needed to hold that it was limited to Chapter 68 because there was another way to decide it. Just based on, FBAR penalties are not even part of the Internal Revenue Code. They're provided for in 31 USC, not Title 26. So for example, FBAR penalties would clearly be outside the scope of what's covered in 6201A. But the language in 6201A is, all taxes, including, and then this little list, imposed by this title or accruing under any former internal revenue law. So an additional amount under this title is covered by 6201A. And that phrase additional amount is also undefined and very unspecified in the code.
Thank you.
Thank you.
We'll give you some rebuttal time.
I was just going to reserve 2 minutes if that was okay. Thanks.
May it please the court, I'm Edward Robbins. I'm the lawyer for Mr. Farhy. I'm with the firm of Hockman, Salkin, Tasher, and Perez, a tax firm in Beverly Hills. Before I get into the specific points I want to make, I wanted to say that the case the tax court wrote in this matter is magnificent. I mean, I thought I did a good job of briefing it. I'm not even at the same zip code as she was. It's correct, comprehensive, well-reasoned. She hits virtually every issue that's there. I really can't do much to add to it, and hopefully I won't say anything to detract from it. What I would like to respond to is, I mean, if the court is concerned about the collection due process that I can answer some of those questions. We are here on the result of a collection due process. That's how we got started. So very briefly, and I've done a number of these things for the taxpayers, you can't, as a practical matter, you can't get to the merits of your tax liability through a collection due process. And it was not designed to do that. It was designed to make sure that the collection procedures were correct, everything's in order, the taxpayers are getting consideration for their complaints. I can't pay this, or maybe the assessment's late, whatever. It's very rare that you can finagle a merits determination to the tax court through a collection due process hearing. Normally, you'll get a letter as the IRS is trying to collect from you. You'll get a letter, and the first one will say, if you don't like this, you can go to appeals. All right, that's your opportunity right there, according to the IRS anyway.
Go to appeals, meaning the Office of Appeals?
Yes, yes. So that's your opportunity, and if you have your opportunity, you can't get to the merits into the tax court. We didn't go to the merits in this case. We just skipped through all that. We went on the core jurisdictional basis for the collection due process. We were challenging the quote mode of collection, and so we never got into whether we'd have a prior opportunity or something like that.
So what's your strongest authority for the notion that if there weren't a parallel proceeding as there was in Our Country Home, if there was, just as in your case, standalone, well, there was the criminal proceeding, but if there was a standalone notice of the filing penalties, discussion of the merits with the appeals office, then assessment, then pre-collection, collection due process opportunity, or not, in your view?
Yes.
Yes, so that would be available. And then if you went on appeal to the tax court from there, the issues raised on liability before the appeals office and the issues raised on whatever ability to pay or calculation before in the collection due process, all those would be rolled into the tax court appeal. Is that right?
Believe that's true. There's an anomaly with the government's approach that we've heard here this morning, and I want to bring this up because I think it's important. You look at their briefs, you see a theme here that Congress could not possibly have written this 6038B penalty with no assessment authority. Impossible. It's a quote, absurd result. It's an anomalous result. No way Congress could have intended this. And we hear this theme over and over again. It's at pages 11, you see it, page 21 of the original brief, page 22, page 29, and the reply brief at page 2. Without any support, they assume Congress would never have intentionally withheld assessment authority for the 6038B penalty because that would be absurd. Let me suggest it's far from absurd for Congress to withhold assessment authority on the 6038B penalty, as well as many other information penalties. The 6038B penalty is not alone. There's at least 16 others in the foreign information realm that don't have specific assessment authority, as we don't have here. Why would Congress want to do this? Well, they would withhold the IRS's supercharged collection powers from the IRS when they try to collect on these penalties. And there's a good reason for that. And in fact, the government gave us a clue as to that reason. On page 6 of their original brief, they note that Congress, when they were looking at the 6038B penalties, this is in the congressional record, Senate Report 97-494, Congress was concerned because the 6038B penalty could be, quote, unduly harsh in some cases. Well, indeed, it can be unduly harsh in some cases. And in fact, it is unduly harsh in thousands of cases. And we set that out at the joint appendix, pages 169 through 181. What happened was the IRS decided it would be a good idea to systemically assess some of these foreign information penalties. And the first experiment they did was a 5472, which is the analog to the 5471, but for companies. And then they went to a second one for the analog to the 5471 to partnerships. They did systemic assessments, which means if you're the taxpayer, and they did this to thousands of people, if you're the taxpayer and you find out, oops, I should have filed a 5471, and you file it late, they systemically assessed you a $5,000 penalty. You put your reasonable cause statement on the 5471 and you give them reasonable cause, they are instructed, you find this on the internet, by their own rules for their employees. The employees are instructed to ignore the reasonable cause assessment, the reasonable cause argument, and just go ahead and assess. And if the taxpayer wants to raise reasonable cause, I guess he can raise it somewhere else, but not here. So this taxpayer trying to get in compliance, trying to do the right thing, files the tax return, files the 5471 late, and they hear from the IRS in the first instance, you owe us $10,000.
Was this in your brief?
Yes,
Where?
it is. I cite the joint exhibit, page 169 through 181. I don't have my brief in front of me, but it's there. It's in the joint appendix, and I referred to it in the brief. It's basically a horror show.
Well, what about the government points out in their reply brief, on pages 13 to 15, that essentially your proposed interpretation of 6201A would mean that some penalties that Congress specifically intended to be accessible wouldn't be accessible under your reading. And the example that they give is, I think, section 45. IRC section 45. So what's your response to that?
Well, my response to that is the same response I give for the Farhy situation. There's either a specific assessment authority for the penalty or additional amount or anything else, or there's not. And if there's not there, Congress hasn't put it there, they can't assess it.
Well, in,
And
40, in 45, I guess it's B7, B Romanet 2, it says deficiency procedures shall not apply with respect to the assessment or collection of any penalty imposed by this paragraph. How are we to construe that other than that Congress intended that those penalties are to be assessable penalties?
Yeah, I think that's the way you we could construe that with that language. That language, something analogous to that language isn't present here in these foreign information.
Well, what about
Well,
the,
how can it be assessed if there is no specific authority to assess it, either in 6201A or elsewhere in that section, IRC section 45?
Well, in my opinion, it can either be assessed or it cannot be assessed. And if you're telling me that thing says it can't be assessed, then it can't be assessed. I'm
Well,
not familiar with that.
you're-
I'm not
you're te-
familiar with that section.
Well, I mean,
In the reply
it's
brief.
in the reply brief. They say that your interpretation of 6201 results in kind of a nonsensical result with respect to this section because Congress intended for that penalty to be assessable. But if 6201A doesn't give them that authority, then nothing else gives them that authority. I mean, that's your contention, right? Is that 6201A does not confer any general authority to assess penalties.
Correct.
Okay, so the authority has to come from the actual provision that creates the penalty itself, right?
Not necessarily. I'm okay with the theory that there are other things that parenthetical could capture. But they have to jump through some hoops to get to there. It has to kind of look like a tax. It has to have something to do with tax, such as interest on a tax. You know, they can assess that. But there's no tax element to the foreign information penalties. You can't look at the foreign information report and say it has anything to do with tax. It's just a report about facts. It doesn't fit in that parenthetical. All of the other elements have some kind of tax aspect to it.
Well, what about your friend on the other side's reply brief where they say, well, the tax court got that wrong because the fixed dollar penalties are very much like lots of other penalties that are included in Chapter 38. Do you say that they're just wrong about that? They're really not like those other penalties?
I'm sorry, could you do that again?
So the reply brief points out that they believe that the tax court simply got it wrong by construing the fixed dollar penalties of Section 638 as completely different than the other sorts of penalties that are in subchapter 68 that are accessible.
Well, they're specifically made accessible in 68.
I understand that, but the tax court believed that the 6038 penalties are just like completely different character or type of penalties that aren't similar to any of those that are in subchapter 68. And I think the opening brief and the reply brief of the commissioner says, well, that's just not correct. Those fixed dollar penalties are similar to lots of different penalties that are in subchapter 68.
I agree that there are penalties in Chapter 68 that are accessible, and they're accessible, for example, the 3520 penalty for gifts. There's no specific assessment authority, but for other things covered by 3520, there is specific assessment authority to assess that. So Congress can and has, in my view, picked and chosen various and sundry taxes to be accessible or not accessible. The reason you might deem it or cause it to not be accessible if you're in Congress is you don't like the penalty and you may be persuaded to vote for it, but I want the enforcement mechanism cut back, because that will cause the IRS to take a little bit longer to look at these things and not do something like summarily assess with no contact at all to the taxpayer, summarily assess 10,000 penalties for billions of dollars, only to turn around 6 months later and abate 80 of them because they're wrong.
So you don't question whether there's authority to assess the penalties under 6038C? which are the offsetting percentages of.
Yeah, the offsetting percentages, I think, have a tax element to it.
Right.
So if there's a tax element to it, yeah, they can assess that. That would, oh, that's a good point. That would fit in the parenthetical. If they had bothered to put it in there, it would fit in there nicely.
Okay. But what about the coordination problem that I was asking Ms. Ugolini about? If there's a case that involves 6038C penalty, but also a 6038B, then that would presumably go under two separate tracks because the 6038B penalty is not deficiency. It wouldn't ride along with the deficiency that from which the tax credit is going to be
Right.
offset. And so you'd have liability on 6038C going to the tax court.
Okay.
And under your theory, you'd have liability for the 6038B going by an action from the Justice Department to a federal district court. What if they come up
Right.
different with conflicting?
Well, that's, I guess, an administrative problem that pops up from time to time, but
But it's a serious administrative problem because then you have this randomness of whichever reaches judgment first would be binding on the other, or is there a hierarchy?
Well,
between
that's
the
a-
tax court of the federal district?
in my view, that's a problem they'd have to work out because there's no assessment authority for the 6038B penalty.
Why shouldn't we read that as a reason that Congress assumed that the 6038B penalty was assessable? Because then it would be as under in our country home that IRS could hold the assessment of that pending the resolution of the tax court. If the tax court said no liability, they'd let go of the filing fine. the penalty.
They have 5 years to sue for it. That should be plenty of time to work the element out. They have 5 years to sue to collect under my theory, to collect the 6038B penalty. So I don't see a conflict coming up. Why would Department of Justice, number one, probably isn't going to take it anyway if it's not big enough. That's the key to this switch. And if they do, if say it's a big number, they say, well, we're going to have to cover this number. That should be easy without interfering with anything else. I'm sure the Department of Justice would just continue the thing until the tax court worked the other one out. That's the way you work that.
So part of your response to the absurdity is these are relatively small penalties. They're there kind of more as deterrence than as something that is regularly going to be collected, which is, the true of various provisions of the tax code. And that the members who voted for it were thinking it's more of a message, a bark, than a bite.
I would not agree that they're small penalties. $10,000.
Well, they do add up.
$10,000
In that
penalty.
situation,
Yeah, a $10,000 penalty on the front end is big to me.
it may be big for the taxpayer, but for the Justice Department, I'm not so sure.
Oh, the Justice Department wouldn't touch that with a 10-foot pole.
That's my point. So under your theory, those would, that you're seeing this as more of a big, in your view, a big bark, $10,000. That's going to encourage people to file, but it's not going to be often collected.
I think, well, this is urban legend or inside baseball. I think DOJ has a $100,000 cap on the Farhy referrals.
Precisely.
Which makes sense.
So my characterization is correct in your view that we're trying to think of what would Congress's purpose be. And I hear you saying, and put it in your own words if you want, I just want to understand that this is not absurd. It's not incoherent because it's a message to taxpayers. You better file. And they don't necessarily know whether their case is going to be one that, how many people in the field know that there's a $100,000 cap?
I just blew it.
Well, now you have a chance to recover.
You can blame me. Yeah, but it's a serious penalty, and there's no reason to think the taxpayer is necessarily just going to blow it off. The IRS can still send out the done letters and the increasing threats. You better pay this, or we're going to sue you, and stuff like that.
And
I'd
when,
say,
as in Mr. Farhy's case, it gets to be above $100,000, they're going to actually come after you.
There's ways to deal with that. I think that the procedure of making what I call the supercharged collection powers unavailable to these foreign information penalties is a good move. Because what they did, IRS did when they exercised the powers, unlawfully in my opinion, but they exercised them, they made a mess. And it's right there in the record.
You had a rebuttal to the government makes an assertion that if the Section 6038B penalties are excluded from the expanded definition of tax under 6201, that would not only gut the IRS's ability to assess, but also to make inquiries or determinations of the penalties. And you argue, well, the IRS has plenty of authority elsewhere, and you point to 7601, 7602.
Yes.
And as I read those sections, those really empower the IRS to examine books and witnesses to determine the correctness of returns.
Yes.
For liability for taxes. But in the situation of 6038, there isn't a return involved.
Right.
Is there? So that wouldn't apply.
No, it would apply. In the real world, assuming our theory is correct, and you cannot assess the 6038B penalty for a 5471 late filing. In the real world, if the government wants to get into that form, they can do it. They can do it. They can collect all of that information on the 5471 form in the context of a tax examination of the taxpayer. There's no defense a taxpayer has that, oh, you can't see that because there's no assessment authority, C6201A. That's not going to work. The test for the information gathering capacity of the IRS is the broadest thing imaginable. They can get anything that may be relevant to the investigation. I can remember many times standing in front of a judge and they asked me, well, how is that relevant, Mr. Robbins, on the summons enforcement? And the answer was, I don't know, maybe. That's the test. And
So
you
it's-
don't
so
know it
they're-
until you see it.
So they're going to be able to, in
Oh, sure.
investigating whether the form is filed.
Sure.
You're not seeing examining books and witnesses related to the correctness of returns. It could be the correctness of the absence of a return. And
It could be anything. The information gathering capacity of the IRS is the most broad thing I think you can imagine.
so you put little stock in the inquiries or determinations argument of the government.
So let's see. Well, am I over?
You are.
I have
Yeah.
a question. So there are some provisions in Title 26 where Congress said that the tax penalty shall be enforced by a civil suit.
Yes.
And they say that in Title 26.
Yes.
You're saying that, okay, they didn't do that here in Title 26, so they have to rely on this kind of catch-all civil enforcement statute that's in Title 28 at 2461, right?
Well, I think I always understood, and I could be wrong in this, the penalties or the sections that have a specific command from Congress that you can only collect this through a civil suit. I always assumed that was you send it over to the Department of Justice and they do their thing and collect it. I don't think there's another, I don't think the IRS goes into court on their own. They refer it to DOJ.
Whether it's the DOJ or the IRS lawyers who are bringing the civil suit, my question is more focused on in the tax code, Title 26, there are some penalties where it says there in the tax code, this is to be civilly enforced.
Yes.
It didn't say that with 6308. You say that, well, we read in that, well, it can be enforced through the kind of general authority to enforce.
Yes.
Through civil enforcement under Title 28 outside of the tax code.
Yes.
So what other penalties do you believe are enforceable under Title 28 civil enforcement? All of the ones that you listed in your brief?
Yes, and I will make a disclaimer. I kind of put those together on the fly. There's a lot of them. I think there are 16 foreign information penalties that track the Farhy situation with no specific assessment authority. And for those, in our view, under our theory, for those, ultimately, if the taxpayer is forced to pay, they will be taken to a civil court and district court and sued for it. They'll have a demand for pay this amount, give us $10,000. They say no, send it over to the Department of Justice, and they will sue them to collect a debt of the United States. It's a debt of the United States. And in the process of that lawsuit, they can do liens, they can seize property, they can do whatever you can do in a civil suit in district court. So there is a
Only after
remedy.
they've established a judgment. That's the.
But that's right.
So it's a very different burden.
Yes. Oh, no, it's,
And can you provide any example where that has happened with any of those penalties that you list that have to be enforced in that way?
I can't because the IRS is assessing them. In my view, they are illegally assessing these penalties. So the answer to the question is no. But I haven't seen a $100,000 case be forwarded from the IRS to DOJ tax. But sooner or later, they're going to have to start doing that.
So under your view, for example, in 26 USC 7272, there's a penalty for failure to register. It's not referred to as an assessable penalty. It's just referred to as a penalty of $50.
Right.
And it doesn't say that it has to go to court and recover it in a civil action. But your position is, if the United States really wants to collect that,
Sure.
if it doesn't get it voluntarily, it has to go to court.
Yeah. So unless they have assessment authority, there may be.
But you're saying they don't.
Well, yes. If they are lacking assessment authority, the only other alternative that they can
Well,
beg the taxpayer to pay it,
My question
and
is,
they might get a voluntary payment.
if it doesn't say assessable penalty, and it's not in Chapter 68,
Mhm.
then under your theory, it's not an assessable penalty.
Correct.
Okay,
And the remedy is to
go to court.
go to court and sue. And there's obviously an administrative problem for the IRS with that because DOJ is not going to take a $50 case.
Judge Rogers, did you have other questions?
No.
Wilkins?
Thank you, Your Honor.
Thank you very much. We especially appreciate the experts on.
I've been doing this for 44 years.
Longer than this provision has been in effect.
Yeah. Don't remind me.
All right, Ms. Ugolini, you reserved or sought to reserve.
I sought to reserve 2 minutes. I just have a few points to make, so it might be less than 2 minutes. I just wanted to point out, I think that I heard my colleague concede now that the parenthetical in 6201A could cover other things that are not specifically listed there. And if you take a look at page 11 of our reply brief, we listed there 6 other types of penalties that operate similarly to the 6038B penalty in the sense that they are fixed dollar reporting penalties that are not necessarily derivative of a tax liability. I just wanted to make a couple points in response to what my colleague said about sort of like what he characterizes as systemic assessment problems with this penalty. You know, in this case, there were no challenges to the penalty, the legality of the penalty, ability to pay, those types, all the types of complaints about fairness or ability to pay that could have been raised in a collection due process proceeding were not raised here. That's at pages 14 and 15 of the joint appendix. That is the appeals officer's termination after the CDP proceeding.
Your friend said that you can't really get into challenging the merits of the collection due process proceeding. Do you agree with that?
You for this type of penalty, you can, because there's no prior opportunity to contest your liability. And this goes back to the discussion that Judge Pillard and I had that goes back to Our Country Home case. In a collection due process proceeding, if you did not have a prior opportunity to contest the liability or the amount, then you can raise that in a collection due process proceeding. He did not raise that here. And I would just also point out that this is a case, if you look at page 93 of the joint appendix, Alon Farhy signed a non-prosecution agreement in which he agreed to pay all applicable taxes, interest, and penalties, and yet here we are.
You should have added a sentence there that required them to, agree to that they could be assessed. The time to get someone to agree to something is when you have the gun to their head, not after.
Your point is well taken. Well, I'll not reach my last point. Unless the court has further questions, I would just ask this court to reverse the decision of the tax court. Thank you.
Thank you. Case is submitted.
Case number 22-5170, Andres F. Cabezas, appellant versus Federal Bureau of Investigation. Mr. Horwitz for the appellant, Mr. Walker for the appellate.
May it please the court, I'm Brian Horwitz for the appellant. We're here today with respect to an appeal of lower court's ruling on cross motions for summary judgment, as well as its unexplained denial of appellant's unopposed motions for discovery and in-camera review. Our position is that the court below erred by issuing orders with respect to our motions without providing explanation, specifically the motions for in-camera review and for discovery, and by failing to address all of our non-frivolous arguments in our motion for summary judgment, and contrary to the other side's, the FBI's motion for summary judgment, and by reaching impermissible factual conclusions in its order. This court has the power to remand this matter back to the district court for full review and determination on each of those motions, so that a full record can be established and our client can have a chance to get all of the documents that would be responsive. I can go, so the court will start with the first one, the motions for discovery and in-camera review. The court issued an order that did not contain any explanations about why it was denying them. And in US v. Gaskins, as we cite in our briefs, when a court vested with discretion makes a decision that is neither self-explanatory nor supported with any reasoning, it should be vacated and remanded for explanation rather than having the Court of Appeals guess as to its grounds.
The discovery and in-camera are available, but they're not routinely engaged in. In fact, quite the opposite. In FOIA cases, they're very rare. And so I guess the question is, when the declarations that the government has submitted satisfy the district court that segregation is adequate, that the documents have been adequately reviewed and defined, that the exemptions are appropriate, it's typical in those cases that there is not discovery and that there's not in-camera review. And so given the nature of Judge Nichols' ruling on the merits, is that not sufficient support for his exercise of discretion on those two extraordinary procedural steps?
I mean, I suppose that's the FBI's position. If we're looking at this, we're alleging misconduct. We see that there are documents that haven't been produced. We see in the FBI's production and redaction, I should say, of documents, there are redactions that are clearly erroneous.
But those are things that are teed up for you to challenge without discovery or in-camera review. I mean, you're articulating the points here. And so those ordinarily are reviewed on appeal and reviewed by the district court without in-camera review.
Well, I mean, the primary thing that we wanted with the in-camera review was this arrest report. And I think we cited case law. I know we cited case law specifically in our brief, in our reply brief, addressing the fact that in-camera review can be a tool used by the district court in that situation. And in this situation, specifically here, the FBI basically did not produce the entire arrest report on a couple of exemptions. I think it was 7E and 5. We got a lot of arguments back and forth and a lot of briefing about both of those. But ideally, from our perspective, the district court was in the best position. Hey, they can analyze. We were saying that those exemptions didn't make sense, especially given that some of these documents had already been released, and especially given the nature of the document. We talk about the fact-based versus attorney communications, and it would have just been very easy and appropriate for the district court to say, okay, let me look at
As
this.
a former district court judge, I would say that I would push back that it's just very easy and appropriate to have in-camera review every time a lawyer asks for it. That's the whole reason we have these rules in FOIA cases where we have the whole Vaughn index procedure in the first place. So you don't have to do that because there's a bazillion of these cases in the district court. And we don't have the time to do in-camera review, and it should be reserved for instances where you really can't discern the merits of the arguments based on the papers that are filed. So why couldn't the district court make an intelligent and informed decision based on what was filed?
I mean, I guess we go back to the fact that we had provide factual reasons for attacking various of the other documents and various of the other exemptions, and the district court didn't really adopt or accept or even utilize those attacks in any of its decisions. Here we had a 15-page document that, as far as we know, contains potentially factual things and other things that had already been released, and we disagreed with the exemption, but it was a limited motion for in-camera review. It was a 15-page report.
You're talking about, now you're raising a 7E, what you think is an inappropriate application of 7E to the arrest plan. Is that what you're talking about?
Yes, and these two, I should say,
I mean, the presence of the theoretical presence there of factual information, no doubt there's factual information in that plan. The government has said that is, the way that it's organized and teed up and discussed and identified is going to reveal law enforcement techniques. And you're able, without in-camera review, to argue about that. But I have a prior question, which is, I don't think I referred to 7E at all in your opening brief. And in this court, if you don't raise an argument in your opening brief, that argument is forfeit. And I did not understand you to be challenging the FBI's invocation of exemption 7E. Am I wrong?
We actually had challenged it in the court below.
That's true, but we're a new court. We don't go back and reread your district court briefs. I mean, we do sometimes, but it's not how we frame what we think you brought to us.
Understood. And the way I saw it is, your honor is correct. We didn't, as far as I can recall, I don't recall if we put that 7E in the opening brief, but it was something we were replying to because the FBI raised it in their opposition. So it was within the scope of something we could address once it was raised in the opposition.
Well, our circuit rules require the appellant to raise the issue. And I mean, a lot of your briefing is taking issue with what the district judge did, but we're here on de novo review. So we're not really here to re-examine and fly spec the way the district court did things. And I understand that one thing that you're asking for is something that could only be done in the district court, which is the discovery. I mean, we could do in-camera review here, but we typically don't. But setting that aside, we're here listening to you on de novo review. So you should make on the merits any arguments that you have. You're concerned about the arrest plan, I've heard. What about you make in the district court anyway, argued about the screenshots versus the text of the interaction between the defendant and the putative minor. That information is available. The information that wasn't provided is not the exact same, it's a different format. I'm not sure that that's releasable under the public records or, public domain exception.
I mean, I suppose and this goes back to the discovery motion itself. The concern that my client had, that we had, was that there were discrepancies. There were, it looked like post-dated records. We talked about the allegations of mishandling of documents, and the fact that the FBI actually in their original production produced something, and then only after we filed litigation did they actually go in their brief. They talk about, oh, we went and found these things in Tampa, but that was only after the litigation was filed. There were 4 total productions of documents, and I believe those were all 3 of those were after the litigation was filed. So it has been our position the whole time that the FBI was holding back on documents and misapplying exemptions.
So you need to walk us through this, at least for me. You've talked about misconduct, you've talked about post-dating. I'm not really following your theory here. What you think happened and what the support for that is.
Well, what we think happened among a couple things is, before that, what we want is to be able to just say we've gotten a full production from the FBI of all of the documents that have been requested. What we think happened was that there was agent misconduct, and that the evidence of that agent misconduct has been withheld or obfuscated or kept outside of the required CRS system where those documents should have been kept.
All right, so some documents were produced from, what is it called, the satellite office,
the field
the
office.
Orlando, yeah, and you're arguing in part about the adequacy of the search. And the argument there, to me, actually, I'm going to have to ask the government. They don't explain why the person who they asked to do the search did it, why other people weren't asked to search, what they were searching, what terms they were using to search. So there's some real questions there about the adequacy of the search. But putting that aside, you imply, or correct me if I'm wrong, that the fact that the documents kind of trickled out is itself an indicium of wrongdoing. But in our experience in FOIA cases, we do not read misconduct from the fact that some documents come later. I mean, people are digging for stuff. When they find it, they produce it. But I take you to have some other basis for your misconduct allegations?
The misconduct isn't necessarily the trickle of documents out. The misconduct is that the records were kept outside of the system that they were supposed to be kept inside of, or intentionally, or otherwise. And
so your remedy for that is to explain why the search was too narrow and ask for broader, as you did effectively with getting the documents that were outside the CRS system. And your further argument about that is?
It's hard to confirm that all of the documents that were outside of the CRS system have been produced.
We understand that is the general argument, but the problem is, give us some specifics. And what about the fact that I think you argued about, there were some emails.
Thank you, Your Honor. I mean, that's a clear example, right? We produced an expert affidavit saying that because of the way that this investigation was or action was conducted, there necessarily have to be other emails in existence and records in existence related to interactions with Craigslist. The government never responded to that. The court didn't address it at all.
Wait, I think there was a response to that. Go ahead.
But the FOIA requests were for documents related to Mr. Cabezas. And so what your expert said is that, yes, there would have been some emails about just basically from Craigslist about like setting up and creating the email account. But those emails wouldn't have been related to Mr. Cabezas. They were just related to setting up the email account generally. So they're not even responsive.
I don't know that they were only just that. I think Mr. Demetrios also indicated that there would be correspondence back and forth while the emails were anonymized, that would be through Craigslist that were not produced. Whether or
All
not
right, what about Judge Wilkins' point about how is your client directly affected?
Well, I mean, he's entitled to request all documents related to anything he asks for, as long as it's
And
not
what did
subject
he
to
ask
exemption.
for specifically in this respect?
You know, I don't actually have the, this is silly, of course.
No, it's not silly. We're trying to.
No.
The
Your
argument
request is not silly. I'm sorry.
And one question I had
Sure.
was that you did have some expert testimony about Craigslist and how it functions. And yet, though you were asking for this type of document, you never got it. And your argument, I thought, was that they didn't look in the right place. Am I wrong about that?
That's one of the arguments, is that.
Well, we only need one at a time, okay?
Sure.
And maybe you want to stick with your strongest one, given Judge Pillard's point about what our standard of review is in these cases.
I mean,
So I'm looking at one of the arguments that may be persuasive. So I want to get you to make the strongest argument you can as to why you think the district court erred and why this case ought to go back on the adequacy of the search as to those emails.
Sure. And this goes back to the assertion that we have and the evidence that we produced showing that the records, or at least some of these interactions, were done on a T-Mobile cell phone that was not FBI property. It had an attributable IP address. And the fact is, the record search doesn't seem to have addressed those other offline, outside of resources that were improperly used by these agents in their investigation. And that is the point. We can't get to those records because they held them away. And the FBI either, doesn't have ability to say after the fact, when those records haven't been properly put into the FBI system, hey, here's the records, because they don't have them in their possession, even though they should. And the FBI agents themselves are required to submit everything that they access to that system.
My indication is that the FOIA requested any and all records under my name and/or identifier assigned to my name, and then it listed kind of types of records that he was listed to, that he wanted. So the FOIA request was specifically linked to records under Mr. Cabezas' name. And so that's why when I look at the declaration of Mr. Demetrios, that's your expert, right?
Yes.
Okay, I look at that declaration, and the first 17 paragraphs basically establish, his background, experience, expertise. The money paragraph for our purposes is the final one, paragraph 18.
Yes.
And he says, okay, here's how Craigslist.org email system works. And he says in that final sentence, the posting individual receives emails from Craigslist relating to the initial posting of the advertisement, management of the advertisement, and forwarded communications from people responding to the advertisement. Now, all of that is referring to what the agent would have received, right? Not what Mr. Cabezas would have received. Am I correct about that?
Those are things the agent would have received because these are on this is on the agent's side of the use of Craigslist, but that doesn't mean that they wouldn't refer
And-
to or mention Mr. Cabezas.
Well, I don't see anything in paragraph 18 that tells me that any of those sorts of emails that is being referred to are necessarily going to refer to Mr. Cabezas by name. I mean, my overall point here is that in these FOIA cases, we have said the court doesn't have to like oversee a search that results in finding every document imaginable that might be responsible. The court has to oversee a reasonable search. And to the extent that you say that the search isn't reasonable and they should have looked elsewhere, you can't just say that. You have to give the court some reason to believe that there might be something elsewhere. And you have to identify what the elsewhere is. You have to say, this is the other place that we think needs to be searched that hasn't been searched, because the court can't just order the FBI to search everywhere else outside the CRS system. And what the court did here was it got a declaration that said, okay, we reached out to the officer that the agent that had custody and control and management of the case file. And we asked that person, is there anything else related to Mr. Cabezas that didn't make it into the CRS system? And they found some things, and those things have been turned over or have been withheld and appear on the Vaughn Declaration. What else is the court supposed to do at that point?
Yeah, I mean, Your Honor, we raised the two places that potentially could have other records that we think have other records. Those would be, and we talked about it. We provided evidence regarding the T-Mobile phone, and we also talked about Agent Heyer's prior.
Wait, what are the two other places?
T-Mobile phone and whatever personal computer of the agents here. So we talked about, and I'll get there in a second, but the idea was we presented evidence that one of these agents had been previously reprimanded for conducting this kind of operation from a personal computer as opposed to an FBI computer. It's our position that that's what happened again here. And so there are records in that place that haven't made it. And then if the agent that's being asked, hey, do you have any more records, has a disincentive to provide things that are on their personal computer because that's how they already got in trouble or their partner already got in trouble, they're not going to produce those documents. What's
the basis for inferring that an agent may have used their personal computer in investigation of Mr. Cabezas?
Two bases. One is that IP address with the T-Mobile phone. That's
a phone, not the computer, right?
Correct. You're right. You're right. But that's an outside source that's not FBI that we don't have any records about.
Now, you are assuming some things that aren't apparent, at least to me.
Okay.
I mean, does the FBI never use T-Mobile phones in undercover operations?
This gets a little bit more technical than I'm really prepared to discuss, but there's an attributable versus unattributable IP address issue here that, at least my understanding, is if it had been coming from a government phone or a government device, the IP address wouldn't show up the same way it did with respect to this T-Mobile.
But you don't think the government would use a phone that doesn't appear to be a government phone when it's doing undercover?
Either way, if they did or didn't, then the original record should have been submitted. But it's my understanding that the government agents aren't supposed to use non-government devices and
all I'm saying is this could be a government device, but it could be not through government IP address because it's part of an undercover. And the other thing is, I thought they provided all of the mobile phone. I mean, the prosecution was based on, or the charge was based on the mobile phone transcript.
So, I think that's a different phone that you're thinking of. That's my
Oh.
client's phone. So I believe,
Oh.
that was the transcript taken from that particular
Well,
device.
if it's from the client's phone, then why would, so you want the agent's phone to cross-check the accuracy of the transcripts from your client's phone?
We have a couple of records, and we cited to them in our briefs, where it looks like things have been backdated, or it looks like things are missing. And so, yeah, that would be ideal. Or at least, like I said, going back to
Those arguments went over my head. I did not, in reading your brief, what I thought was carefully, I did not follow your points about backdating or deleting. Can you just tell us what you're referring to?
yes, hold on one second. I'll pull up the actual page numbers, so I don't have to speak in ambiguities. Apologize. So the backdating records, there was a footnote, and we're referring to JA 514 versus JA 603, and there was a slight discussion about, at one point there's a discussion of Mr. Cabezas being on this printout that the FBI did provide in their FOIA production. One version of it says prior to the arrest, prior to the meeting him, that he was dangerous, and one did not. And it was unclear why there was a distinction. The only thing that made sense was that someone had gone back and added that for some reason and backdated.
So the argument in your brief that is linking to this is where? Just so that we have it as a reference?
Yeah, it's hold on one second. I think that might
You
be,
refer to a footnote?
I think it's a footnote in the reply brief, but it's also, I believe, well, no. Page 15, footnote 7 of our reply brief, it's mentioned. I believe it might also be, I believe it's also mentioned in the underlying brief. But it's definitely mentioned there, and it's in the record.
So where in your opening brief do you say that the district court erred because it did not also order the FBI to search T-Mobile phones or personal computers of agents?
I guess we didn't say it explicitly that way. We talked about the misconduct and the fact that it was our belief that these records should have been reviewed in some way or shape or another. But I don't know that it was explicitly stated as succinctly as you just put it, Your Honor.
Well, the question is, was the district court on notice of what your argument was? And you're
Yes.
acknowledging no.
These were the bases for the motion for summary judgment, the opposition for the motion for summary
No,
judgment.
I understand you made the broad arguments. All right. So now you're asking us to reverse for failure to do something very specific. But you never alerted the district court. That's what I hear you responding to Judge Wilkins' colloquy.
I think we raised these in our motion to amend. I think all these specific issues were raised multiple times in the court below. Judge Wilkins was, at least as I was responding to, was talking about where it was in our initial brief in front of this court.
No question about it. Okay, it's not enough to say the district court erred. Why?
What? Say that again. I'm sorry.
And I thought that's what Judge Pillard was asking you about in terms of changing of what the email said and things like that, and telephone. What's your other strong argument?
I mean, I think we go to the other side of this, is that misconduct various misconduct allegations. The FBI did not, FBI, we specified some misconduct allegations. We talked about a few of them here now. The FBI didn't really address them other than to say in their brief in the court below that we hadn't specified anything. We demonstrated at court a couple of different times that we had specified what we thought was alleged misconduct, at least as detailed as we could based on the information we had.
For
And
example,
the iPhone thing, I mean, the Verizon phone, but the other big one that was, I think we haven't even talked about today is the records pertaining to and the actions around the agent's attempted return of what was evidence, this iPhone, Mr. Cabezas's iPhone, to Mr. Cabezas in prison while the appeal was still ongoing. That was another allegation of misconduct that we cited to as a reason for why other records and should be unexempted or why we had a right to see them.
So yeah, explain to me, that sounds peculiar that when there's
was
an
peculiar.
appeal going on, that something that was evidence. Now, presumably, I mean, I gather one of the things that you say the government is wrongly withholding is the screenshots that it has kept somewhere of that phone. But what flows in your mind, or what could flow? And I understand this is why you wanted more discovery, but the goof, why is it insidious? What is it trying to do or revealing that is prejudicial to Mr. Cabezas's FOIA entitlement? The attempted giving back of the phone. It's like, okay, it's not taking care of evidence. That phone is apparently no longer evidence because it seems to be wiped of stuff. But
I don't know that it is wiped of stuff, Your Honor.
well, when the brother was looking at it, things weren't showing up. Yeah,
That's true. He said that some things were not in there. The phone is an interesting kind of mess, right? It's a digital record that we have not been able to access. They tried to give it back while it shouldn't have been given back. We would love to have seen it and see it and give it to our expert to analyze it for various purposes, because we think that there's records on there that would be beneficial to my client. We either can't get the phone or we can't get the phone in the wrong way. So the way it was that the agents tried to give it back was indicative of, I don't know what, negligence or insidious intent to cause my client to be committing a further crime while in prison, receiving this device, which the FBI.
but that's not before us. So they mishandled it. What FOIA record or information that your client wants has he been prevented from getting?
I mean, I suppose that the contents of the phone are, especially the communications that are on there versus the screenshots that have been submitted, would be demonstrative of any differences or misconduct.
But if
What's-
yeah, go ahead.
What's your authority that screenshots are not, under FOIA, are not a permissible substitute for the actual raw data? That if there's a bunch of emails that the government can't turn over, printouts of the emails, the government has to give you the emails in electronic format. Is there any FOIA case that's ever held that's what has to happen?
I haven't briefed that particular issue, so I don't have that at my fingertips, Your Honor.
Just stepping back and thinking about the FBI did this search of the Tampa field office and located the two materials that you had identified as missing, the phone recordings and the photos of the arrest scene. Are there other responsive materials that you suspect are missing from the Bureau's production that lead you to conclude that still that search isn't adequate? Well,
I mean, I think the prime example, it's hard to guess what's not there, but the prime example would be the records, and Your Honors have addressed this already, but the records pertaining to the Craigslist advertisements and correspondence that permeated that system. those would be records that we would think would exist. We're fairly certain that they exist, but we haven't seen them.
Anything else?
Off the top of my head, I don't know.
How about you pointed to these Bates numbers 160 and 226, saying that the FBI wrongfully redacted Cabezas' name from those, but and then you point to, I think, Bates number 91 to say those documents refer to Cabezas, but the documents at 160 and 226 have a different case number from the 91 documents. So it seems like it maybe wasn't Cabezas. Do you have any response to that?
Without having anyone ever seen this unredacted document, I don't know who it would refer to. It does, there's no other individuals that were indicted or related to this indictment as far as I'm aware in the criminal investigation. And I mean, going to page 160, I believe Your Honor just referred to that. The name Cabezas is Andres Cabezas is listed on there a couple of times. So
So where are you saying it was wrongfully redacted?
well, so that was an example of a wrongful redaction, right? I mean, to the extent that it says to document the indictment of redacted, who else could it be? If it is someone else, that would be an explanation that would come from the FBI, but I don't understand how that would make any sense. Why would this indictment memo or communication refer to indictment of someone else when it's all about Andres Cabezas?
Just questioning whether it would be someone else because it has a different case number, but you don't have any explanation for that.
I can't imagine an explanation for that. I don't understand. I can't imagine a factual situation. I mean, short of a typographical error, either in the name, which is repeated multiple times, and the specific date, right? The description, the details does pertain to Cabezas. Every component of it does. So I don't understand. I can't comprehend what other name would be under the synopsis paragraph when everything in the details below refers to Cabezas.
All right. And going back to your arguments about exemption 7C and 7E, you argue that there's information that should have been segregated and released, but you're not arguing that the documents themselves are not records or information compiled for law enforcement purposes. You're just arguing about the breadth of what that covers in those
Right.
documents.
They blocked the whole 15 pages or however many pages it was. It's completely not produced. So yeah, I would think that some of the information, especially to the extent as we talked about before, has already been produced, or has been, is no longer part of an ongoing investigation. It can be produced. So yes, it could be segregated out or redacted.
Any further questions? Judge Wilkins, Judge Rogers? Mr. Horowitz, did you reserve any time for rebuttal?
I reserve 2 minutes.
All right, we'll give you 2 minutes.
Thank you.
Mr. Walker for the United States?
Good morning. May it please the court. Johnny Walker, representing the FBI. Your Honors, I think what the declarations and our briefs in this case describe is a very routine FOIA request to the FBI by the subject of an FBI investigation for all records under that individual's name or any number identified with that individual's name. So in response to that request, the FBI undertook a search of the indexing system that it uses to index investigative files that are indexed to a person's name. It located the file with records under Mr. Cabezas' name and processed everything in there for release. The exemptions applied, everything in this case is covered by a law enforcement exemption, of the kind that you would expect to apply to records in a law enforcement investigation file. There are some underlying subsumed exemption 5 and exemption 6 withholdings as well, but everything here is covered by the type of law enforcement exemptions you would expect to see in a case like this.
Now, this investigation was conducted out of the Orlando Maitland
I believe
an
it was the
agency?
Tampa field office that was contacted about additional information from Mr. Cabezas.
Well, that's why I'm asking. The investigation was conducted out of Orlando, Maitland, or out of Tampa?
I know that what the declarations indicate is that the special agent who was responsible for Mr. Cabezas's file was in Tampa. That was the individual contacted for the sort of targeted retrieval of the additional records.
And why was it targeted? I mean, so they just went and asked him for the things that Mr. Horowitz had identified?
Yes, that's correct, Your Honor. So the initial search that was conducted by the FBI was, I think, clearly reasonable in relation to the request. As for documents and records under Mr. Cabezas's name, the place where the FBI stores those files is in its central records system, which is indexed to individual's name, and it located the file containing records under Mr. Cabezas's name. During the course of litigation, Mr. Cabezas's counsel identified specific records that Mr. Cabezas believed should have been under his name, but apparently were not. So in response to that, the FBI made an inquiry to the case agent who was responsible for Mr. Cabezas's file, or responsible for the investigation records, to ask whether or not there were any records that were not in the file that related to Mr. Cabezas's
He
investigation.
wasn't the only agent who was involved in this case, was he?
I'm aware of I'm not aware of the agent that was contacted. I'm aware of 2 agents that were involved in the case, and the agent who was contacted may or may not be the same. The agent who actually corresponded with Mr. Cabezas undercover and was the primary agent for the case was Agent Kaufman. And there's also reference to an agent Hire, who I believe was the coordinator of the child exploitation unit.
And so the question is, once there was reason to believe that the CRS did not contain all responsive documents because the requester gave the Bureau reason to believe that there were other documents, the scope of the ensuing search is not very fully explained. And you've helped me out by saying, well, what they did was they went and tried to find the documents that he'd identified. But my understanding under our precedent is that when there's reason to believe that the search that was conducted was not sufficient to identify, all reasonably available documents, that a further search should be conducted more broadly, that there should be, let's contact the people who worked on this case and ask them if they have anything responsive by these same terms or, in some other more categorical description. But my understanding is that that was not done.
Well, what was done, Your Honor, and I think it was reasonable and well described in the declarations. We know that the initial search was of the CRS system, and the only documents that there was reason to believe were not in that system were certain specific documents that Mr. Cabezas's counsel identified in the litigation. That was the arrest photos and the 2 audio recordings.
I'm not sure that that's the correct inference. I mean, there were documents that were not included. The information that the requester had was that there were these 2 categories that he could imagine should be in the file. But, as you know, FOIA is kind of putting your hand into a black bag and not really knowing what you're looking for. And so there is the burden shifts then to the government to show, well, in response to this shortfall, we've taken the next step, which is realizing that CRS didn't have everything on this investigation. We've looked in the places generally for information relating to the investigation where other information might be found. It doesn't sound like that step was taken. It's a general look for other information in other places.
I think it was general, Your Honor. What the declarations describe is that individual custodian at the Tampa field office, the inquiry to that individual was, are there any records at all that are about Mr. Cabezas that are not included?
Point me to which declaration you're talking about.
Yes, Your Honor. I'm talking about, I believe it's the 3rd Seidel declaration, and this is on page JA 649.
A targeted search of the Tampa field office, contacted the special agent, requested a search for any additional documents the SI maintained outside the case file.
That's right. Any additional documents?
Any additional documents that fill in the blank.
That were not in the
Usually
case
we-
file.
Like, he's got a whole filing cabinet, but so the nexus to this case is not explained.
Well, Your Honor, I think,
Typically there's some further description of the search.
sure, well, I
We have to
think,
review it.
yeah, I think there's
Whether
two.
it's adequate.
Understood, Your Honor. I think there's two different types of searches that you see performed sometimes. There's sort of the centralized search, which is the search that the FBI initially performed here of a broad system. That employed search terms. It employed going through hits to determine whether or not they're responsive. And you often see in these cases a more targeted search in which individual custodians of records are contacted and asked to retrieve any documents that are responsive to the request. And there can be, dozens, hundreds of custodians in any individual case, and you don't necessarily describe each and every folder that individual clicked on. What you say is you inquire of the custodian. We understand you're the custodian of this type of records. Please provide anything that's responsive to the request. And that's what occurred here.
But the question is, if somebody who is the custodian, that typically we have from you declarations that would say, CRS is the main repository, everything's forwarded to it. Occasionally some things aren't forwarded to it. In that event, it would have been forwarded from the agents involved in the investigation to the custodian of records in the field office. We confirmed that was done here and therefore contacted only the custodian of records, or, some records weren't forwarded and therefore we contacted all the agents who were in the investigation and asked them to search in their hard copy files and on their desktops. I mean, there's nothing like that that sort of tells us what was the targeting? Why was this person chosen? Are we finding it reliable that this person is a custodian of all the records? Where did he find the things that he did produce? Did he call up the other agents, or were they on his desk, or were they in a file labeled Cabezas? So we don't really, as a court, have the usual indicia that we are able to rely on in, the unusual FOIA context where we rely on the government's affidavits.
Your Honor, I think you start from the position that the CRS generally contains all of the FBI's investigatory records. So everything would reasonably be expected to be located there. And our declaration, the second Seidel declarations, explains in some detail why that is so. That is the system that the FBI uses to respond to FOIA requests. It's also the system that the FBI uses to carry out its core law enforcement function. This is how the FBI retrieves the records that are central to its mission. So you start with that assumption. All the records are going to be contained within the CRS. And then during the course of litigation, counsel points this out, a limited set of records that appear to have been overlooked, that weren't in the CRS. You might say that arguably they're not responsive to Mr. Cabezas' request because they're not under his name. But the FBI contacted, and it explains the individual that it contacted. It contacted someone who maintains plaintiff's criminal case file, the person who maintains the file. That's the custodian, and they were contacted because they maintain that file. They were asked to search for any additional documents that agent maintained outside of the case file. And they found precisely the two categories of documents that Mr. Cabezas indicated as having been overlooked. So I think that cures, and I think even Mr. Cabezas has said that specific, the ability to locate those overlooked records cured at least that objection to that aspect of the FBI search. Your Honor, I just want to address, you were discussing with opposing counsel his contention that the FBI redacted his own name from certain records. As Your Honor pointed out, the case numbers are different on those records. Mr. Seidel also addressed that allegation in a declaration and said so very explicitly that the FBI, quote, did not withhold plaintiff's own name within the record. That is at JA 658. That is not Mr. Cabezas' name. It's not any variation of his name. It's not any misspelling of its name. It's a completely different name, and so it is properly withheld. I want to address briefly also the backdating allegations. This is based on two different versions of an NCIC report that is in the record. Now, those two different versions are different in many ways. One is—
Before you move on, I'm just
Sure.
thinking about this question of the supplemental search. I think that Mr. Horowitz had also, or maybe it was Cabezas at the time, had also identified there was some kind of a log And that wasn't actually.
That was identified in the reply brief, Your Honor. It was not mentioned in the opening brief,
Right.
but there was the initial, the FBI in this case initially claimed a broader exemption 7A exemption because court proceedings were still ongoing. Once those court proceedings resolved in favor of the government, it began processing records for release. Now, that, I think it was a 1087, FD 1087 was mentioned on a Vaughan index in connection with that earlier 7A withholding. It is not mentioned in the current Vaughan index, and that is because it has been released to Mr. Cabezas. It is in the joint appendix at JA 464. If you look in the top left-hand corner of that document, FD 1087, Federal Bureau of Investigation collection item log. So that accounts for that.
60.
464, Your Honor.
JA 464?
Yes, Your Honor. So that is the FD 1087.
And the ensuing pages?
I believe it's just one page. Oh, no, yes, the one ensuing page, I believe.
No.
Oh, yes, that's a 302, correct.
Yeah.
Yes,
Just one
that's correct.
page. Okay. That's helpful. Thanks.
Sure. On the backdating, that's referring to two different NCIC reports. If you look at those reports, they're two different reports. They are, one is more fulsome than the other. Both of them have information redacted. And so I don't think that they lend themselves to a one-on-one comparison to determine whether or not they're obviously going to be different. Certainly, the presence of additional information in one rather than the other does not indicate any backdating. And certainly, it does not indicate any flaw in the FBI's handling of this FOIA request.
On the Vaughan index, there's a description of records, Bates numbers 167 to 216. The Vaughan index refers to them as undated photographs, but the FBI declarations describe them as undercover communications. So these are screenshots of undercover communications with Cabezas. So that's why they're in one place described as photographs and another place described as communications.
I don't want to reveal more information than the FBI has put into the declarations and get into some law enforcement sensitive information, but I will confirm, Your Honor, that they are both photographs and communications.
They're both photographs.
Yes, they are
and
both of those
communications.
things at the
They
same
meet
time.
both definitions.
That's correct, Your Honor. And they are withheld as under exemption 70.
And so in the FBI's declarations, those text messages have already been released?
The text messages with Mr. Cabezas that the FBI maintained on its own side, that it had full chain of custody for, those have been released, as well as all of the communications. My friend was referring to communications through Craigslist. Those emails have been released.
And he wanted the agent side phone?
I think he indicates that the agent, everything from the agent's side that was the communications with Mr. Cabezas from the agent's side have been released. They were part of the investigation file and they were released in full, or at least with minor 7C redactions. My understanding of the agent phone is that's his contention that an IP address linked up to a T-Mobile ISP. We think it's a total non sequitur to get from that to the conclusion that somehow the device that was used to use the T-Mobile ISP service was not covertly purchased, or that it was a home computer. It's a total non sequitur, and I don't think it has anything to do with whether or not the FBI processed this FOIA request in good faith and released the information that it had. Like I said, the communications from the FBI with Mr. Cabezas, both the Craigslist emails and the text messages were released. Does the court has any further questions?
Judge Rogers?
Oh, thank you.
Thank you. Please affirm the district court.
I'm back. I would just briefly, and thank you for the extra 2 minutes. I won't use all of it. Briefly just point to the idea, and your honors have raised it very recently. The agent that was the custodian of records in this case, gave additional records when they were doing that were not contained in the CRS report. I don't think we have an affidavit from that underlying agent saying that they have produced everything and that they were able to get everything. It's more of a secondary declaration. So I would just point out again that
Confirming what he was told or what the reports show.
no, so confirming that all of the records that custodian himself in Tampa actually had that were responsive had been produced, right? Because the I was
What
Seidel.
about the third Seidel declaration? Any event, you don't need to worry about it. We'll just look it up.
Okay.
Well, you're arguing that Seidel can't testify to hearsay in his declaration.
Exactly. He doesn't have personal knowledge of the records in Tampa. He's not in Tampa.
But we almost never in FOIA cases get firsthand declarations from the people who actually conduct the search. We get secondhand declarations from someone who, oversaw the search.
I suppose that makes sense, especially when things are kept in a centralized location. I think the concern, it's always been my client's concern, is that the things weren't kept in a centralized location. And so the idea that the person who's overseeing the search can testify what their procedures are for keeping the records and can testify about the scope of their search and who they talk to. But when you've discovered specific records that were outside of where they should have been and they were held by some other custodian, I don't know how they can testify. And
What's your best case on that?
Say that again. Oh, I don't have
I mean, that was the implication of Judge Wilkins' question.
yeah, I mean, it's hearsay.
all
I mean,
the
it's
time.
just an evidentiary.
And I'm saying, what's your best case?
I don't have a hearsay case in front of me on this particular issue. I could draft a letter for you, but I don't have it.
But you do have a citation? A case citation?
With respect to, no, this is, I don't have it with me today.
All right, thank you.
And so the things you had identified that led you to believe that the materials that you got from the supplemental search were inadequate, you said were the phone and the potential personal computer?
And yes, the IP address, T-Mobile IP address, and the computer, and the fact that at least one of the two agents involved had previously been reprimanded for doing exactly what we think happened here.
Higher.
Did you ever argue in the district court that the third Seidel declaration, at least to the extent that there were paragraphs that talked about what subsequent search was done in Tampa, that declaration should be stricken because it's hearsay?
I don't think I made that argument.
All right. Thank you so much, Mr.
Thank you.
Horowitz.
Thank you.
Mr. Walker, the case is submitted.
Case number 22-7167, Diana T. Valle et al., appellants versus Antonis Karagounis, governor et al. Ms. Perron for the appellants, Mr. Krause for the appellees.
We'll hear from you when you're ready, Ms.
Thank you.
Karen.
Good morning, Your Honors.
If you want to, the podium, the lectern can be lowered by a switch over on the right.
It's okay. Used to being a little bit on the shorter side. Please the court, Claudette Ferran, appearing on behalf of appellants, Diana Valle et al. Today, appellants argue the appeal of the district court's erroneous ruling, turning the established law of summary judgment on its head by using an anomalous interpretation and perverse application of the legal standard to a seemingly one-eyed review of the record. As established by decades of precedents codified in the federal civil rules and taught in first-year civil procedure, summary judgment is only appropriate if, after assuming all facts and allegations, assertions made by the non-moving party, appellants, in this case, to be true, and drawing all reasonable inferences from the evidence in the non-moving party's favor, it can be determined that there is no genuine dispute of any material issues of fact. Moreover,
Can you help me understand what facts do you believe are genuinely in dispute that are material? Identify 1, 2, or 3, the most important.
the most important one, I believe, Your Honor, is whether or not the policy, the alleged policy of the appellees, was race-based or race or ethnicity applied. Out of nowhere, we get an affidavit from the appellee's manager saying, this is our policy and it is unilaterally and equally applied to all customers. There's no evidence in the record other than the affidavit of the manager who was not present at any of these events. On the other hand, we have the testimony, deposition testimony of the appellants, number of the appellants. One, I believe it was Nekti Gaska, who indicated that she was told by one of the waitresses during the incident in January that the reason for this application of this policy to this family of Latino women was because they have problems with people of color. Then we have the evidence of, I believe it was Ms. Tybe, who indicated that while she and her fellow diners ate or waited, they never got to eat, waited to get their food, they observed a white party, a Caucasian party come in, sit down, receive their water, their drinks, their appetizers, their meal, their dessert, finish their meal, and then pay by credit card, all while this group of Black women sat and waited in the back around an ottoman, around a coffee table and an ottoman. And then I believe we have some additional testimony from, I believe it was Miss Aaliyah Sullivan or Mr. Williams, in which they indicated that they did not see anyone else during the brunch being asked to prepay, and they were the only couple of color in the restaurant at the time. I believe that's sort of the core of the issue.
So with respect to the statement of the waitress, That's hearsay. You can't bind the defendant because she's not a manager. So under the admission of a party opponent rules or exception or hearsay definition, however you want to articulate it, statement by the waitress is not admissible to prove the defendant's liability or to be, so I'm not sure where that gets you.
I would,
You do agree that that's the way that I think it's Rule 802, the admission of party opponent rule works.
I agree, Your Honor. However, we do have the statement of Mr. Karagounis on the website where he says, this is our policy, and he does that more than once.
I understand. I guess what I'm trying to understand is the theory of your lawsuit is well, if you say that the theory of your lawsuit is that they did this because they had issues with people of color in their mind not paying, and that's the reason that motivated them to create the policy. I don't see how that gets you a claim, even if that were true, unless the policy were discriminatorily enforced. Even if there was a discriminatory basis for creating the policy, if the policy was implemented with respect to all customers, then I don't see how you have a claim. Am I missing something there?
Yes, Your Honor. And the fact is, it is our contention and the evidence shows that this policy, whether it be legitimate or not, is not unilaterally applied.
Well, that's I'm trying to separate these two things. One is you seem to be saying that one of the disputed issues of fact is, was the policy race-based? I took that to mean that you were saying that, well, we think that the policy was created for some sort of racially discriminatory reason. I guess what I'm saying to you is that I don't see how that's really a material dispute of fact, because one, the only evidence you have of that is one statement that's hearsay that doesn't fit within the admission of a party opponent. So you don't have any evidence other than that I saw from the briefing that the policy is race-based. So you don't have any admissible evidence of that. But secondly, even if you did, I don't understand your theory to be that, well, just because it's race-based, it's illegal, even if it were applied to all customers the same. I don't see that argument in your brief, or is that argument in your brief, or what's the support for that argument?
I don't believe we argue that directly. I believe the argument is that it is whatever the policy. First of all, we don't necessarily believe that it is a legitimate policy, because we, the appellants, asked for documentation of this policy and were not given anything in discovery. And it was a matter of fact, during discovery, we were, the appellants, or excuse me, appellees, indicated that there is no written documentation or anything other than this affidavit that they produced that indicates that there is such a policy. So the policy issue itself is suspicious. We also asked about training on this practice, and they said there's nothing, it's just verbal. The issue that is most critical, I believe, is to the extent even if there is a policy, it is not applied unilaterally. It is not applied to all customers.
So you seem to be saying a couple of different things there. One is that you think that there's a dispute of fact as to whether there actually is a policy? Is that one of the?
That may be also a dispute, Your Honor, because they say that there is a policy, but on the one hand, they say there's a policy. On the other hand, they can produce nothing related to this policy other than this verbal statement.
I have to admit, I had a lot of trouble with this case in the sense that there's supposed to be, under the federal rules and under the local rule, a statement by the moving party of what they believe the undisputed facts are. And then the opposing party is supposed to go through point by point and indicate, we dispute this fact, and here's the evidence that disputes this fact, or we don't dispute this fact. So that the district court can then know, okay, what facts is the plaintiff claiming to be in dispute here, and then can make a ruling as to whether this fact really is in dispute or not.
Correct.
I couldn't make heads or tails of the pleadings to figure out whether that was really done here, because there were these voluminous statements of undisputed facts and voluminous responses, and it was very hard for me to get to the bottom of that. But I guess where I'm going with all of this is that I didn't really, maybe I missed it, but to the extent that you are arguing, and you argued in your opening brief, that there's a dispute of fact as to whether there really is a policy, what is the evidence that you have that places it into dispute? Because if they have a witness who testifies under oath by affidavit or declaration that we had the policy, and they have your clients who testify under oath that they were told that there was such a policy, what is the evidence that places into dispute whether there was such a policy at all?
The fact that we requested from the defendants, appellees, copies, any kind of documentation other than just the verbal statement of this
I have
policy.
policies for what my clerks can't do, what my secretary can or can't do. I don't have it all written down. Does that mean that I don't really have a policy?
Well, with regards to an operation involving a one-on-one relationship, I think it's different when you're operating restaurants. And in this particular case, you have supposedly they're alleging that there is this policy. However, when they're asked for the policy, when they're asked for training information regarding the individuals who are allegedly required to enforce or apply this policy, there is nothing. They admit they have nothing.
Let me ask you, counsel, under Brady and our three-part test, the defendants say they have this policy. And at least the facts of this case, it's sort of an interesting policy in the sense that there are exceptions to it. And so far as I can see from the factual case you do present that's admissible, your argument in part is not only did the district court state the summary judgment standard in the defendant's favor, And I would agree that the way it was framed quite negatively, but the district court opinion does include in there, would you not agree, that he was obligated to view the record most favorably to your clients?
That
And
is
my
correct.
second point would be that in these discrimination cases, if you isolate each fact, you can say no discrimination, that's unlawful. But if you put it all together, something was going on here that your clients under oath say was discriminatory. So at least to your prima facie case, if you have to show it, could say it's made. And then the defendants come along and say, we have this policy. And I didn't really see you arguing that there was no policy, in the sense that I thought your argument was the defendants may say they have a policy, and let's even assume they have a policy, but there are exceptions to it, and at least your client's view is that it was not being applied across the board, that they were being treated differently, and they were being treated differently because of their race. As I understand it, that's your case that you presented to the district court. And the district court basically came back, as I understood it, and said, you just haven't offered enough evidence. And in their brief, they point out how there's all this that could be presented at trial to show that your clients can't, or that you wouldn't win a jury trial. But that's not where you are, as I understand it. So the question in my mind is, under our Brady decision, and I was proceeding on the ground that under Brady, defendants had established that there was a policy. And your argument is maybe so, or even assuming that, but there's no showing that it was applied across the board. And the defendant's response is, all you offered was speculation. You don't offer any evidence that the policy was not, you don't proffer any evidence that were you to go to trial, this policy was not applied to everybody who was in the restaurant. And that there wasn't enough to show, given the defendant's explanation for the policy and why it was the business reason that the defendant offered, that simply was not enough to meet your sort of threshold burden here. How do you respond to that argument?
First, with regards to any explanation as to business reasons, this brings us to the issue of trial by affidavit. When you talk about
Counsel, I'm trying to get you to move beyond that, all right?
okay.
Because I didn't understand, and maybe I misunderstood. I thought your argument was the defendants say they have some sort of policy. And my clients have offered evidence that it was applied in a discriminatory manner, unlawfully. And the district court basically took the position that there's a lot of speculation here, that your clients have offered evidence of what they think was happening, but they have no evidence. They don't even proffer that were this to go to trial, they could present evidence that this policy, however vague it may be, and it's not in writing, wasn't being, at least as the defendants describe it, wasn't being applied across the board.
If I may respond?
Please, yes.
We have 3 separate incidents involving 3 different groups of minorities at 3 different times. These minorities didn't know each other than there was a family of the Valles. There was the group that was with the T. Spence, and then there was the Williams and Sullivan group. These 3 groups all offer testimony that the same thing or similar thing happened to them. They did not observe anyone else who was Caucasian being asked to prepay for their meals. The 3 separate incidents arising at 3 separate times mutually corroborate each other, and I believe are sufficient to take to a jury. In addition to the testimony of, with regards to the separate incidents and the 3 separate groups who were strangers to each other before this litigation, we also have the testimony of Ms. Teeb and Ms. Spence, who during the occasion with their girlfriends were sitting there and watching what happened with the Caucasian group when they came in. And with regards to the Valle family, we do also have evidence, apart from what may be considered hearsay, evidence proffered by, I believe, all of the Valle members, that they did not see anyone else being required to prepay. And if you keep in mind that the the nightclub had just closed, so people were shifting from the nightclub to the restaurant. So it would be assumed that if this policy was even-handedly applied, the Valle family would have seen this policy be applied to other patrons of the restaurant. They saw no such thing. In addition, once they decided that they weren't going to prepay, the sequence of events that followed would seem to, or is sufficient enough to take to a jury to indicate that this policy, to the extent it is a policy, is applied in a discriminatory fashion.
So with respect to the Sunday brunch, there was testimony presented by the affidavit and maybe elsewhere that there were basically 2 ways that brunch could be set up. You could either pay online and reserve your table and show up, or you could go in and eat brunch and then pay, after at the restaurant, right?
Correct.
And so, to the extent that your clients didn't see other people paying, what the defense argues, and I think what the district court ruled, is that that doesn't really give you enough evidence to go to a jury there, because we don't know that there were like any other people who were similarly situated to your clients at lunch, in the sense that they came in without having paid in advance. That appears to be the reason. So give me your response to that. If I'm wrong about the reasoning, please correct me. Or if I'm correct that that is the reasoning and that is the argument, tell me why that argument shouldn't be adopted by us.
The argument shouldn't be adopted by this court because would be trial by affidavit, which is precluded by Supreme Court.
But you have the burden of proof in the case to prove the discriminatory application. And when you refer to affidavit, I assume you're referring to the defendant's affidavit?
Yes.
But you, in discovery, ordinarily what you might do in a case like this where you're testing whether there's a policy and what its nature is, what its roots are, is to notice a deposition. And you can, even if you don't know who adopted the policy, do it under Rule 30b-6 and say, please produce for deposition the individual with knowledge about this policy. And then you would not be here with leaning on their declarations, but you didn't do that. So you have,
we did
their declarations are competent on summary judgment because presumably the declarant can then come into court at trial. So that's, we have declarations, affidavits all the time at summary judgment.
In discovery, we requested the policy, we requested the training, any evidence of the training.
We don't have paper on it.
We don't have anything of any nature with regards to the existence of the policy, with regards to the training that anybody receives, it just doesn't exist.
But to surmount summary judgment, you need to then follow up and say, why do you think that's suspicious? Many businesses, especially things like food industry, they don't run on paper. They run on person-to-person contact. And so if you think that's opening up a lot of leeway for discriminatory application, it's your burden to show that. And so when you talk about trial by affidavit, that is summary judgment. It's giving us the dry run, often in affidavit form or in deposition transcript.
Well, in this case, while we only have the affidavit of the appellee's manager, we have 8 depositions of plaintiffs, which are being were dismissed by the district court.
I don't think so. I think the question is, what do they show on the pertinent point? They show what people observe, but they also say, well, why did I think it was discriminatory? I can't think of any other reason, right?
Well,
or, what's the basis for your conviction that it's discriminatory? It's just speculation. It made me feel suspicious.
Well, I think what the court is referring to is an inference drawn from the facts. And drawing inferences from the facts is the jury's province, not the judge. And in this case, I believe the appellants had more than sufficient testimony based upon the entire record of what happened to them and what they observed to take it to a jury and let the jury decide whether or not those observations, those incidents, those events were sufficient in the jury's mind to draw the inference that there was discriminatory behavior.
So here's to, I guess, follow up on Judge Pillard's question, kind of get to the brass tacks. With respect to the brunch, let's suppose there was a trial and the evidence was essentially the same as what we have in the record now. Is that your clients testified that they were asked to pay, they looked around, they didn't see anybody else asked to present a credit card. How would the jury conclude, without knowing anything else, whether the other people who weren't asked to present a credit card, how would the jury know whether or not those people had already paid online?
It would be, if there was nothing else in the record, that was an indicia, a possible indicia of discriminatory conduct or a disparate treatment. But there is more in the record with regards to the brunch incident. In the record, it is, and there's deposition testimony, that before being allowed to enter the brunch, Mr. Williams was searched, body searched, and Miss Sullivan was also searched. They said they did not observe anyone else being searched. You then get into the restaurant and they're told to sit anywhere. Then they go and do what they're, one goes to the bathroom, the other goes to the buffet, and before they can, get back, barely get back, they're asked to prepay. Now, the question becomes, is their observation, because they had a conversation with the manager or bouncer, whoever he was, and the waitress, indicating that this is unusual. I've never done this before. We also have testimony.
Never done what before?
Never been asked to prepay before. We also have testimony in the record.
The plaintiffs say they've never been asked to be.
That's correct. We also have testimony in the record.
But I'm not sure that proves anything with respect to whether that's unusual for this restaurant.
I was about to add to that. We also have in the record the testimony of Miss Valle, who had been to the restaurant numerous of times and had never been asked to prepay for.
But she explains that herself by saying that she was with an individual who was a friend of the owner, an individual who was in the restaurant industry. And so she knew that the policy wasn't being applied to them because she thought they were being comped.
She never knew that the policy wasn't being applied to them. She didn't know there was a policy.
Exactly. So it's just, she herself characterizes in a way where it's not indicative of anything. And presumably she also was her same self and her same race and ethnicity at that time.
That's correct. I still, it is our position that given the record, notwithstanding that these are observations, unfortunately, a lot of times discriminatory conduct is based on observation. It is rare that a defendant or a party will come and say to you, because you are Black or because you are Latino, I'm doing thus and so. It has to be inferred from the circumstances. It has to be inferred from the body language. It has to be inferred from corroborating other incidents. It has to be inferred from the sense of the individual who is.
I agree with all of that. Just to kind of get to the nub of it. I think that the brunch, I think, is a more difficult thing evidence-wise for me to understand what evidence that a jury could have other than speculation where we don't know the circumstances of these other people who were being observed by the plaintiffs. If all of those people had prepaid online, then their observations that they didn't see them being asked for credit cards kind of doesn't really prove anything. I think that the circumstance is a lot different and a lot stronger for you for the after 10 p.m. situation, because there everybody should be similarly situated, right? Everybody who's coming from the nightclub or coming in after 10 p.m., they haven't, there's no evidence that any of them would have prepaid online before they got there, at least that I saw on the record. So to the extent that the plaintiffs say, we come in, it's after 10, we're asked to prepay, we see all of these other people come in also after 10, we don't see any of them as, presenting credit cards. or any form of payment to either run a tab or to prepay, however you want to call it. To me, that's easier to infer from the plaintiff's observations that there is a disparate treatment. So I think that like the after 10 p.m. seems to be a different kind of circumstance than the brunch. That's why I'm just trying to like nail down exactly what the evidence is that causes there to be a dispute of fact with respect to kind of each of the sets of claims.
I think, as I mentioned before, if each of these claims was a separate case happening at a completely separate time in separate jurisdictions, if there was just one case, indeed, we would be in a situation of, well, that's what the plaintiffs think or the appellants think, and we'd have to do this inference. But we have a pattern of behavior with this particular defendant. And this pattern of behavior there's sufficient evidence in the record, we believe, to survive summary judgment, because the pattern of behavior is indicative that this alleged policy is only applied to minorities, even when there are Caucasian customers present. So I would agree with the court. If it is only one incident, and there was just one case alone.
That's not my point. My point is that to just kind of break it down to brass tacks, the evidence seems a lot weaker for the Williamses claim with respect to brunch versus the Valles and the Teeb and Spence plaintiffs who are late at night. Because the late at night plaintiffs seem to be kind of by definition similarly situated to whoever else comes into the restaurant, whether at that time, whether they're black or white or whatever. Whereas we don't know whether the plaintiffs who came in for brunch, Williams and Sullivan, are similarly situated to the people that they saw that weren't asked for credit cards. You get my point?
I understand your point, Your Honor. However, to that point, there is testimony that there was no signage or any kind of other information indicating that this was a prepay or pay online type of brunch. There was no indication at the time when the couple came in that this was a pay in advance kind of brunch. I think we've all probably gone to brunches where you either pay online or pay in advance, but we've also gone to brunches probably where, and I know I have, where it's a set price and it is after you've had your meal that you are asked to pay. So that this practice that defendants allege to be benign is suspect in that regard. Also, again, when you put all of this together, the three incidents together, there is a pattern of behavior that is evident. And if the court completely disregards all of the plaintiff's evidence, which it is not allowed to do, and if the court weighs credibility, which it is not allowed to do, it must assume that the allegations, assertions, depositions of testimony, etc., of the appellant plaintiffs is true. With that assumption and drawing inferences, we believe there was more than sufficient evidence from the plaintiffs appellants to take this matter, to survive summary judgment and take this matter before a jury.
Judge Rogers, any further questions? Did you reserve time for?
Yes, I
rebuttal?
did, 2 minutes.
All right, we'll give you your rebuttal time, even though
Thank
we
you.
kept you over.
Thank you.
And we'll hear now from Mr. Kraus. Thank you, Ms. Ferron.
Thank you and good afternoon. Scott Kraus on behalf of the appellees. As has been revealed in the questions from Your Honor during appellant's presentation, this case is truly about the absence of any evidence to take this case to a jury. There are no disputed material facts, and the appellees went through painstaking efforts at the district court level before Judge Nichols to lay out a very detailed statement of undisputed facts, and no disputed facts were identified by the plaintiffs below. There aren't.
Let me see if I understand what you're saying. You filed statements of undisputed fact, which you're required to do under the federal rules and under the district court's local rules.
Yes, Your Honor.
Are you saying that the plaintiffs didn't file responses to those at all? Or are you saying that they filed responses to your statements that did not dispute any of your lists of undisputed facts?
It's a little bit of a hybrid, as I recall, Your Honor. I do not recall that there were actually listings of facts allegedly in dispute. There were certainly arguments made in which the plaintiffs below added more detail from the factual record in support of their arguments. But I intentionally, Your Honor, put the entire factual record before Judge Nichols below, all of the depositions in their entirety. The
Okay, but
interesting
counsel, what we're
interrogatories.
trying to get at, I mean, that's a matter of form, not substance. You put them all in one place, the plaintiffs put them in different, we're trying to get at the heart of this, all right? So that was, I thought, the thrust of Judge Wilkins' question.
Right, and what I'm arguing, Your Honor, is assuming that the truth of all the plaintiff's allegations, there is just no triable issue. There is.
I'm trying to ask something different.
I'm sorry.
Yes.
Because candidly, if I had been the district judge and you had filed what you filed, I would have required you to refile, or I would have just, I would have screamed, bro. Because the goal on summary judgment is to kind of pare down what are the key facts that are material to deciding the case. And to the extent that one side or the other believes that those key facts aren't really in dispute, then they say that, and then they show the evidence that shows that they're not in dispute. And then the other side can say, well, no, that key fact really is in dispute because, we have testimony that contradicts, the testimony of the moving party. What I'm trying to get at is, in the district court, did the plaintiffs say they identified this fact that they said is not in dispute? We disagree. That fact very much is in dispute. And it's in dispute because we have this deposition testimony X. Did they do that?
No, they did not. And the testimony via affidavit from Mr. Aguilar is not in dispute. It spells out the reason and the rationale for two different policies at Rewind. And that is a policy after 10 o'clock of requiring prepayment or collateral put up for anyone who comes in. The brunch issue is entirely separate. And I think Your Honor addressed that in questions to appellant's counsel. But there is simply no evidence and that those
Well,
policies.
let me just cut to the chase here.
Sure.
It's been a long morning. I want to get to the nub of this. If plaintiffs testify that, we are people of color, We come in, it's after 10 o'clock. We're told that there's a policy where we have to prepay and present credit cards, but we look around at everybody else who's come in after 10 o'clock who happen to be white, and we don't see any of them presenting credit cards. Why isn't that enough to raise a dispute of fact as to whether or not this policy is being applied discriminatorily?
Because the record does not support any of the plaintiff's ability to say, I looked around and I didn't see white people not being required to prepay. Ms. Plazas, when she was deposed, conceded she had no reason to believe any other patron was allowed to order without prepaying. Ms. Goska said she did not pay attention to whether any other customer was permitted to order without prepaying. Ms. LeBay said she did not observe anyone else order food at Rewind and does not know whether anyone else was asked to prepay for meals. She went on to say, I don't know if it's racial or discrimination, but I don't think you treat customers like that. Ms. Valle said she did not see any Caucasian patrons at Rewind be seated or served without prepaying. She could only speculate that minorities would have to prepay, but Caucasians would not. I specifically asked each of the Valle plaintiffs if they observed anyone else at Rewind that night not being asked to prepay, and they had no evidence. And if we turn to Tybe and Spence, all they were able to say when they were deposed is that they observed a table with Caucasian patrons settling up at the end of the meal with credit cards, multiple. But as pointed out from the record and consistent with Rewind's policy, seeing someone settle up at the end is not indicative in and of itself that they weren't asked to open a tab when they came in as collateral for the meal. Settling up doesn't mean a credit card wasn't given. And so there is virtually no evidence whatsoever in the record from which a trier of fact could reasonably conclude that Rewind did not apply this policy uniformly. And counsel speaks to a cumulative series of events or a pattern. All the pattern of this three series of events shows is conduct by Rewind consistent with its established policies. There's no evidence that those policies were applied in a disparate manner.
It seems like at least bad business practice. I mean, I'm not in the restaurant business, but to have a policy that's out of line with the typical policy. I mean, at a bar, you do have to open a tab. Typically at a food establishment, you don't. And there are plausible business reasons for having such a policy, but the fact that there's nothing in paper anywhere and there are no signs anywhere to just tell people when they're coming in so that the servers aren't having to have these unpleasant interactions with people who are unfamiliar, does make one wonder whether this actually is a policy or whether it's just something that some of the servers decide to ask about because they've had problems in the past. And I especially wondered that seeing your interrogatory number 4, which says, state whether on any occasion you ever witnessed other patrons be informed of a requirement to prepay. And if so, tell us about it. It sounds like that's a question coming from an establishment that denies having a requirement to prepay.
Well, no, Your Honor, that was my effort to find out whether or not plaintiffs actually had any evidence that would support their claim. And I look,
But you don't ask, and by the same token, did you ever see anyone not be required to prepay, come in and actually not be required to prepay, be seated, be served without being, so you don't ask that question, which is the question one would expect if we're trying to come up with comparators in an establishment that actually does have this policy.
perhaps it should have been a better worded interrogatory, Your Honor, and that may have been a typographical error. I don't recall, but I explored all of those issues in depth when I deposed these plaintiffs. And Your Honor, you may be right that it may be a better business practice to post a sign or have something in writing, but that doesn't make it unlawful. When you read Mr. Aguilar's affidavit and you understand this is a crowded
I
establishment.
do understand. that.
Middle
I-
of the night.
I do understand.
Right,
that.
it's,
I'm just saying
right.
that it's an unusual policy, and as you've experienced, some of the people feel that it's inhospitable, and they may feel that they may wonder why it's being directed at them or whether it's being applied to them. If there's no sign, if there's nothing really, removing that concern or that inference.
And I understand that, and it's certainly a shame that we live in a society where people would be made to feel that way. But the point of this exercise is there's simply no evidence that can go to a jury to prove in any way that this policy wasn't applied uniformly to everyone, or that people of Latina or Black patrons were singled out solely for the application of the policy.
Well, let's play devil's advocate for a minute. You would agree with me that the normal practice in a restaurant is to present payment at the end of the meal, a form of payment at the end of the meal.
I would concede that is normal in certain establishments with wait staff, not exclusive, but yes.
So I guess the other side of it is that if you're going to do something that's abnormal, that might cause there to be some sort of questions or hard feelings, or just kind of make it more difficult for your wait staff who are trying to, keep customers happy and not have them mad at them, so that they'll get tips, so that they, that's why they're working, to make money. That one would, it would be in everyone's interest within the company to post that policy so that there wouldn't be any questions or concerns or disputes or arguments or suspicions, so that the customers will be happy, so that they will be big tippers. And the fact that it's not written anywhere, it's not on the menu, it's not on the sign, it's not on the website, it's not anywhere. I mean, we assume usually that people act reasonably and in their interests. It would be reasonable and in the restaurant's interest to post a policy. So if they didn't do that, and why isn't that evidence that there ain't really no policy?
I will accept, Your Honor, that posting may be a better business practice, but as pointed out, there's no legal requirement to post a policy. And as Mr. Aguilar said in his affidavit, until the events that gave rise to this particular lawsuit, the restaurant had never had any complaint with regard to any patron being asked to prepay. So they had never experienced that problem before these incidents.
Do we know from the record how long this policy had been in effect?
Standing here at this moment, Your Honor, I do not recall. I do not believe that is in Mr. Aguilar's affidavit.
So it could have been yesterday before these particular plaintiffs, these particular defendants.
I know it was prior to these plaintiffs coming to the restaurant, Your
How do
Honor.
you know that?
Because they said it was an established policy
Who
at the
says that?
restaurant. Mr. Aguilar.
Who says it?
Mr. Aguilar, the operations manager.
Oh, I understand that.
Right.
All
But
right, there's no evidence. When you're challenged, you say, well, this is an established policy. All right, that's what the nature, it seems to me, of Judge Wilkins' questions are getting to.
understood.
All right, and to what extent the plaintiffs benefit from that? And your argument, I think, is that all the admissions that were made during discovery destroy the inferences on which the plaintiffs need to rely.
Correct. There's simply no evidence to present to a jury in this case to suggest in any way that Caucasian customers were not asked to prepay in accordance with the policy.
Well, I wasn't clear from the record that there were any Caucasians in the restaurant at this time of night. I mean, that was one of the issues.
Well, certainly Ms. Taib and Ms. Spence identified there being Caucasian customers in the restaurant that evening.
What
Others
time?
At what time, Your Honor? It was early morning hours after 2:30 a.m.
Okay, so after the bar
After-
had closed.
After the other clubs in the area had closed. Yes. I've gone over my time. If Your Honors have no further questions.
Any further questions?
Thank you.
Rogers, any further questions? All right.
Thank you.
Thank you, Mr. Krause. Ms. Ferone, you have 2 minutes for rebuttal.
I will focus my 2 minutes on the issue of disputed and undisputed facts. Contrary to representation of counsel, and I'll be happy to provide this to the court, there was a point-by-point dispute as to disputed facts contained in the plaintiff's opposition to defendant's motion for summary judgment. Not only they had something like 230 sentences or assertions. There was a response or dispute as to each one of those statements, and they were matched up to the statements of the defendant. So for there to be any representation that there were no disputed facts, or we presented no disputed facts at the lower level, is inaccurate. And as again, I would happily supplement this record with the
We can look at the docket and see. I just hadn't done that before this argument.
And in future, that's the first thing you should put in a summary judgment, JA. It's the
Well,
roadmap.
that's one counsel's way.
Yeah, it's important.
It's not a rule, all right?
Well, a part of summary judgment is the statement of disputed facts. And there was a section that was submitted to the court, not in the appellant appeal documents, but there was a section called disputed facts.
Yeah,
Yes.
we'll look, or at least I'll definitely look at the district court for that. What about your friend on the other side saying that none of the plaintiffs actually testified that they really had an opportunity to observe Caucasian diners at night, get their food and not being asked to present a credit card?
Ms. Teague and Ms. Spence both testified that while I believe Ms. Teague for sure, Ms. Spence in part, testified that while they were waiting to get their order and then they were told the order was never put in because they didn't give them a credit card or didn't prepay, they observed a group of Caucasian customers come in, be seated at regular tables, receive their menus, place their orders, receive their drinks, their water, their appetizers, and their meal, dessert, I assume, and then pay afterwards. There's a difference between settling up and prepaying. I noticed that counsel talks about there were multiple credit cards. I'm not sure the record bears that out with regards to the observations of Ms. Teague and Ms. Spence. But even if there was a settling up may have to do with the difference between what you ate. But it does not say that these individuals were asked to prepay. There is a dispute as to what these individuals, namely this white group of customers, were doing, and the practice applied to them, versus the Black customers and how they were being treated. In addition,
Let's assume for the sake of argument that I agree that there is a dispute of fact as to what happened on that night with Ms. Steve and Spence, and also on the other evening. Can you get past summary judgment based on merely those two instances where the policy was not taking the facts in the light most favorable to the plaintiffs, where the policy was not implemented fairly, or it was implemented discriminatorily? Or do you need to, in order to get past summary judgment, you need to establish a pattern in practice?
I think that the pattern in practice is important in this particular case. Again, if there had just been one incident, we probably would not be sitting here. But contrary to the representations of counsel, Ms. Valle testified that she did some research online and found numerous other complaints by minority customers indicating that this had happened to them.
How is any of that admissible?
It would be, I believe, admissible with regards to what, if they are going to assert that there are no other complaints, then it would be admissible as to counter their assertion that there's no other complaints.
But I mean, that's all, I guess that's all hearsay. I don't see how that proves the truth of those matters asserted in those other complaints without getting declarations or from those parties that is what happened to them.
No, I think if we have, and she did research online, so what she was looking at would be online reviews. And those online reviews, provided they had not been taken down now, would be still available online.
But I don't understand how any of that is competent evidence in a court of law. That's what I'm getting at.
Well, the issue, the statement was made by a counsel that there were no other complaints.
Let me just try to narrow down here. I'm just trying to understand the law here. Do you have to prove a pattern and practice of discrimination to get past summary judgment? Yes or no?
Yes.
Sure that's your answer?
No, well, it's a nuanced answer. When you say a pattern of practice, we do not need to show that there was, as to all of these incidents, there's this underlying practice. If the appellees discriminated against the Black group of patrons just once, in this particular instance involving a restaurant serving food, that would be sufficient to get past summary judgment. If we're talking about employment and other types of discrimination, I think you're involving the pattern and practice concept. However,
That's not how I understand the law. You can either prove just an individual instance, or you can prove a pattern of practice and you may get different relief. But the difficulty is when you're trying to prove an individual instance, you have to show either direct evidence of discrimination, someone spoke in a biased way, or a policy was reported in a way that reflects bias based on race, or you often raise inferences by showing similarly situated people who, but for their race, are in the same position as the plaintiffs and are treated differently. And that's why there's so much attention, and why I think Mr. Krause is saying, you know, if people aren't actually claiming that they either saw white plaintiffs, white patrons not having the policy apply to them, and or other patrons of color having it applied, the inference doesn't arise. I mean, this may just be a completely irritating policy. And if I'm Black and I go into an establishment that doesn't have a written policy and they start doing a really sort of irritating and mistrustful seeming policy to me, one of the things that crosses my mind is going to be, are they doing this to me only because I'm Black? What is the story? But then the question of, is that accurate? Is you have to go a step further. You know, I absolutely can see how each of these plaintiffs would wonder that. And then the question is, have they gone the next step and shown it so that someone who wasn't there and wasn't them would say, whew, I see that it really is being unevenly applied.
2 points. One, with regards to Ms. Sullivan and Mr. Williams, they both testified that they did not observe anyone else being treated that way. They also, I believe, testified that they were the only Black customers at the venue. And I think that the question here is, the standard is not the same at summary judgment as if we were at trial. In order to, as the court knows, to survive summary judgment, you have to assume that the assertions and allegations of the plaintiffs are true and take the inferences in their favor. Now, whether you want to, if you call it speculation, I know that as a Black woman, there have been many a time when somebody has done something to me and I believe that it is discriminatory, but that person did not say to me that they were doing this because I was a Black woman. And I could observe that they did not do the same thing to someone coming along. So in discrimination cases, I think the issue of inference becomes crucial to the individual's perception. And I think the inference part of the evaluation is to remain with the jury. It is not to be the judge's.
I need to interrupt to just clarify something. So let's assume that if the evidence showed that on every other day that the restaurant operated, they had a policy and it was applied with respect to everyone uniformly. But, so we had like videotapes, whatever we need to like prove that with beyond the shadow of a doubt. But that the evidence at least created a dispute as to whether or not they treated Blacks and whites differently on these three particular occasions, right? That's what I was getting at when I asked you the question earlier about whether you have to prove a pattern in practice to survive summary judgment. Let's suppose they performed beautifully, completely race neutrally on every other day, but for whatever reason, on these 3 days, these wait staff who waited on your clients decided that they were going to apply the policy or apply a policy discriminatorily with respect to them. The way that these various different anti-discrimination statutes work that are the basis of your claims, do you surpass, is that enough for you to get past summary judgment, or do you need to have evidence that there is a kind of a practice of discrimination as opposed to one-off discrimination on these 3 occasions?
I think all we have to establish is that there was, as to each of the plaintiffs, there was one experience of discrimination. I do not think the law requires us to show, appellants to show a pattern of practice as to each of these plaintiffs. I think that if we can establish sufficiently through the testimony and other evidence that has been proffered by the plaintiffs, that there was evidence that the plaintiff was treated disparately, that one individual was treated disparately, and there was a distinction in race or something that is prohibited, then it would be incumbent upon the defendants to come forward and say that there was a legitimate reason for this. And if we would still then have the opportunity to come back and say that this is pretextual. This is not really the reason why they're doing it. The reason why they're doing it is really because they're discriminating. So in the sense of pattern and practice, we don't have to have a pattern and practice.
I wanted to give you an opportunity.
Yes,
to
I'm
clarify,
sorry.
'cause
So one last question I have for you. Oh, go ahead, Judge Rogers.
No, go ahead.
Is if someone behaves in a really rude way to someone who's in a protected class, woman, African-American woman, someone of a particular religion, and doesn't express it in a way that ties it to their protected class, which is really rude, that person might subjectively draw an inference. This is because, I'm Jewish, or this is because I'm Black. What do you need other than that inference? Like, is that inference enough in your view to take it to a jury? Or do you need more? And if so, what more? To distinguish between someone who just was rude and someone who was discriminatory.
I will, in order to, you need more than just, I feel like I've been discriminated against. You need other evidence in the record, other behavior, short of the person coming and saying to you, I'm doing this because you're not,
you don't have a mind reading machine.
yeah. If they're just rude, they're just rude. However, if you have other evidence that would point to that their rudeness was tied to the protected class, then you would have sufficient evidence to take it to a jury. I believe in this case, the appellants and plaintiffs below have provided more than enough evidence to show that this wasn't just, oh, we feel slighted. There were continuations of behavior. There was additional contextual behavior as to all of these three incidents. Also, with regards to Judge Wilkins, your question about videos, we asked for the videotaping and other kinds of evidence of the events, and we were provided with nothing. So it is not for a lack of seeking evidence that would support the defendants or appellees in this case position that there is some legitimate business practice. The fact of the matter is their statement with regards to a legitimate business practice only came to fore as a result of the summary judgment. They never provided anything. We had discovery before. They never had anything saying, this is our business practice, other than there was an answer to an interrogatory, and then we have an affidavit.
Was there an interrogatory that posed the question that about business practice, whether or not there was a policy with respect to prepaying for meals?
Yes.
Did you propound an interrogatory?
Yes.
Today?
Yes.
And what did that interrogatory say, and what did they respond?
Their response was, we have a policy, and the question was to provide not just we have a policy, but Where's the evidence of this policy? Is it written anywhere? Is there a handbook? Is there training that's provided to managers? How do the wait staff get trained to know how to apply this? And we got absolutely nothing. We're stonewalled. There was not, and actually we're not stonewalled. We were told explicitly there is nothing other than the verbal statement that there's a policy.
But I guess I'm just trying to be precise here. Before the summary judgment briefing, you asked them if there was a policy, and they said, yes, there is a policy, but we don't have any documentation of the
Correct.
policy. Because what you said earlier seemed to suggest that the first you heard of a policy at all was after you filed your summary judgment briefing.
Now, there was.
But that's not the case, right?
There was a delay in discovery. So there was discovery that was propounded, and there was a response. And in the response, they said there was this policy. We asked about the policy, not just, is there a policy, but we asked about evidence of the policy, training related to the policy, et cetera, et cetera. And we were told there's nothing other than our statement that there is this policy, which we believe the statement to be pretextual anyway.
Anything further, Judge Rogers? All right,
Thank you, Your Honors.
thank you very much. Ms. Barone, Mr. Kraus, case is submitted.
Honorable court is not adjourned until Friday, February 16th at 9:30 a.m.